submission.
My lord, RPFC.
It starts from the left side. Yes.
With respect to the value, forget the sub-register value also. It exceeds the jurisdiction of 20 lakh and this court has jurisdiction for Tuesday.
Wednesday. Yes, next.
No, this is the date given matter, my lord.
Huh?
Date given matter
Hmm.
was not listed. That's one.
When is the date given?
Well, 21st it was given, it was not listed. Well, 3 days back I had moved, my lord, your lordship has said today. Well, maybe from my side also there might be a mistake because I mentioned instead of mentioning reputation number, FR number might have mentioned. That is the reason.
Monday? Yes.
My lord, this petition is pertaining to 2021, my lord, challenging the jurisdiction aspect in a MC case, my lord. Kindly posted in next week any matter.
No urgency now. Yes.
And second time notice has been served to respondent. Now the case is posted for a final hearing in trial court.
Which year is that?
Yes, ma'am.
Which year is the writ petition?
2023.
23. We'll see. We'll see. Yes.
Final installment.
We'll see. We'll see. Yes.
But the reason is that injunction order is taken. They have filed a suit for injection that is decreed and the execution has been filed for taking possession of the property or not. That is on the execution is on Monday. Before the agency that.
When did you file that petition? The MFA?
Yesterday.
Yes, lunch motion. Yes. 2:30.
Office objection or complaint.
What is that?
Petitioner.
What is it a writ petition? Is it a MFA? What is it? What is urgency? RPFC of?
We are for petition.
Correct. Which year is
Which year?
RPFC? 24. Yes. Tuesday. Yes. Tuesday.
My lord, RPFC 32/2024, my lord.
The time coming, I'm listening. Why, what is the hurry? Yes.
Being spoken, my lord, in the last date of the occasion, the honorable court was exercising visitation rights of the father, my lord. While passing the order every first Saturday of month and third Saturday of the month. But in
Yes. Give that. Monday. Yes. So you cannot come again here. It should go like that. Then, yes.
I challenge appointment MFA, fresh matter.
Fresh matter, MFA. If it is, no, office objections are cleared, all admission matters will come. If it is not coming, that means you have not complied with office objections. Yes. If you comply, it will come. Don't have to give us it. Yes.
I'm challenging the interim order passed by the trial court, 39(1) and 2. The urgency is this, my lord, the trial court, my lord, has granted stay over the entire extent of land, my lord, so instead of.
When was the order passed?
My lord, impugned order is 6/8/2024, my lord.
Let it come on Thursday. Yes.
Office objections.
Thursday. If office objections are,
Applied.
yes, yes.
This is a fresh matter MFA which had come up for condemnation of delay application on 23rd. Manoj, your lordship had issued notice as well as permitted us to serve it on the advocate in the trial court. We have done the needful measures. Kindly have it on Monday. We
Have it
challenge,
on?
Monday.
Not possible. Thursday, yes.
Please, Monday.
My lord, the stay application is pending. The respondents are trying to alienate the property. Kindly have it.
Which year is MFA?
2023 MFA.
That on Friday, yes.
Yes, my lord, RPFC 2024, my lord. And for the respondent, I have filed wakalat and objection, my lord.
Pose this matter on,
Have it on Monday, my lord.
no, September 17th, yes.
So WP of 2023, we're seeking visitation rights which have not been provided by the.
Tuesday,
respondent.
yes.
This is second time. 2023 matter, the orders.
2000?
2023 matter,
Hmm.
not even passed. No, it's maybe posted for orders, issue notice.
Friday,
My lord, RPFC 2024, my lord. It was filed on 22nd July, my lord. Today, I am filing a memo of urgencies, my lord. The respondent
office objections are complied with.
already wore.
If office objections are
Yes.
complied with, pose this matter on Wednesday,
Please,
yes.
yes.
My lords, land acquisition is claim petition is dismissed, hence preferred than appeal, my lord. All I'm
Fresh
sure,
matter.
please, my lord.
Office objections are complied, it will come. It will
Please,
come.
please.
Yes.
Page wise adjournments, list ones, page one, serial number 1 to 7. Page 2, 8 to 13.
My lord, serial number 13, my lords. Serial number 13,
Yes.
I appeal for the respondent.
Hmm.
My lords, my colleague who is arguing this matter is not keeping well. Hence a short accommodation may be given.
Inform
my lord.
the petitioner.
Well, that will-
So many adjournments, but I
My lords,
cannot
on the la-
oppose you, because there's a-
When do you want?
My lords, any date next week, my lords will.
Pose this matter on Tuesday. No further adjournments will be granted
Please, my lords.
at the request of learned counsel for the respondent. Yes, next.
Serial number 12.
Serial number 16, your lordship.
12.
12.
So the trial court, it's against the ex parte order of injunction and by the trial court yesterday heard the matter. It is posted on Monday, maybe posted on 5th, by that time the trial court dispose of my application, then I can.
Because it's not disposing it off, you file this MFA.
Because of the ex parte order of injunction was granted not to interfere with the.
So what remains in this MFA?
If the trial court does not dispose of the matter, I'll be in a difficulty because I am in possession.
Simultaneously on that application, court is hearing and MFA by this court will hear.
No, right?
Ex parte injunction, that I understood. After that, you file your petition to vacate the stay, that the court is hearing the matter. So what is, why this, how can this MFA be maintainable now? What is this reason? Court officer? Why it's yes,
Trial court is saying since all the respondents is not served, till that time I cannot hear. Then someone, yesterday it was a little bit was, it is posted on Monday. It may be posted.
pose this matter on Tuesday, on the top of
maybe
the
on
list.
fifth- on
12.
fifth May. Maybe
Call the
fifth-
computer people, it's
Maybe on 5th May.
echoing, yes,
On 5th.
no, yes.
Serial number 16,
Next.
your lords. Serial number 16, your lordships.
Serial number?
16,
Yes.
2 weeks time, your lordship.
RPFC of 2023, not even notice ordered. You want 2 weeks time.
I'm the proxy counsel, the council on record has.
Pose this matter on October 22nd at the request of learned counsel for the petitioner. Yes. Yes. No, don't have to call this number 2. This matter. Which one? This, the first one. Counsel is there.
My lord, serial number 1, my lord.
Yes.
My lord, the connected matter, my lord, WP 5774 of 2024.
Call list number 2, sir.
I'm so sorry.
Yes, list number 2.
Yeah.
You appear for the petitioner?
For
Matter
respondent.
settled before mediation.
Huh?
Matter settled before mediation,
Hmm.
because I filed a divorce petition. Divorce petition mediation ended.
Hmm.
He received 15,50,000.
Hmm.
I have filed a mediation report also.
Hmm.
He has categorically admitted that.
When was the mediation?
Pardon?
When was the mediation report?
Mediation is completed on 27th. 27/6/2024.
Appear for the same day.
Yes, in the light of that,
Please.
it can be.
Please.
Where is that report?
Report I have enclosed. Along with this
Memo,
memo,
30th/7.
30th/7.
Give the file. I will look at. give it.
ಮೂವತ್ತೇಳು.
37.
That is the date, 30th.
Memo just.
ಬಂತು.
Worship one submission. Your Worship.
1 minute. The marriage of the petitioner with the respondent, Honorable so-and-so, is hereby dissolved by granting decree of divorce. Memorandum of settlement shall form part of the decree. The RPFC is filed, agreed with the maintenance granted by the trial court.
Why not before that one submission? Para number 5 and 6 talks about.
I'm
this.
looking at it.
No, there is one typographical error. 8, 6, the scene is.
No, all that I'll not, all that will not record. Now in view of the settlement arrived.
They have, here, the 861, 2022, they have typed as 861, 2023. I have informed the other side. I have nothing to do with 861, 2023 is missing.
No, that will not at all record any of it.
I just want. to
The,
tell them.
what is it? Agreed with the maintenance granted by the, order of maintenance granted by the trial court. When the matter came up today, both the council submits that. The matter is settled and they have filed a memo before the court. And as per the settlement, the by order dated 27/6/2024, the family court had passed a judgment whereby the marriage is dissolved by granting a decree of divorce. It is submitted that in view of the said settlement arrived on between the parties, nothing survives in this writ petition. Considering the same, the writ petition is dismissed as withdrawn. This next.
No, if it is dismissed, then the other order will survive because we are challenged the 861 of 22. If my RPFC is dismissed, then that order will survive. It has to be closed in terms of the settlement.
In terms of the settlement, the petition is closed. Yes.
Much okay.
Yes.
Serial number 1, list 1.
My lady, I appear for the petitioner, please. The connected matter 5774 of 2024 writ petition has been reserved for judgment, please. Maybe this matter, I pray that it may be adjourned, awaiting the pronouncement of judgment in that matter, please. That is relating to the territorial jurisdiction of the family court. Yes, yes.
Yes.
I undertake
Section 9
for
matter.
the respondent in this matter.
Mr. Arun Govindraj takes notice on behalf of the respondent, pose this matter on 30th September.
They may
Yes.
kindly be directed to serve a copy upon me. only.
Petition shall serve a
I will
copy
serve
of
a
the
copy.
petition of the council for the respondent.
Much obliged.
Next matter.
Great,
Number
great.
2. Rakshita. Let's in this case, I'm appearing for petitioner, my lords.
Switch on the mic. Yes. There. Yes.
My lords, in this case, I'm challenging the order passed by 5th Additional Principal Judge Family Court, my lords. My lords, the respondent has obtained the divorce on coercion, my lords. It's a mutual divorce, my lords, whereas it is obtained under coercion, my lords. She had, the petitioner was residing with the respondent.
To the impugned order.
Yes, my lords. Annexure B, my lords,
Page number.
14.
Now, have you gone before the court?
Yes, my
Filing an
lords.
application?
Yes, my lords.
What did the court do?
My lords, under coercion, she has gone there, my lords, under the,
No. Now, according to you, this compromise decree is obtained by whatever, by fraud, coercion, whatever it is.
yes, my lord.
Now, did you file an application before the very same court? Because you have to move an application before the very same court. Not
Yes,
file-
yes, my
Where
lords.
is
The
that
pe-
order?
The petitioner and respondent both have filed the application under section 13B, my lords.
You're not understanding the point. You cannot come before the court saying that by coercion, this order has been obtained. If that is the case, go before the very same court which has granted a decree of divorce. You cannot file a writ petition against that. The agreed whether the present writ petition is filed. Agreed with the judgment dated 25/4/2024, whereby the trial court has allowed the application filed by the parties under section 13B of the Hindu Marriage Act. It is observed that the memorandum of settlement filed before the KMC shall form part and parcel of the decree. Land counsel for the petitioner submits that the said decree of judge is obtained by coercion and several other grounds are pleaded. When those are all the grounds that are available to all those grounds are available to the party, and she can agitate the same by filing a petition before the very same court which has granted a decree of divorce, but not before this court. Hence, in that view of the matter, this petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy.
Obliged,
Yes.
my lords. Serial number 3.
Pass over, my lordship.
No, it's not happening, no. What has happened, no, in the morning it was echoing like, from my voice. No, it has said nothing. But every day it's not happening, no, today only it happened. Yes,
Kindly pass over, my lordship. Senior.
pass over, next matter.
Serial number 4.
Waiting for the petitioner in the above case, my lord. My lord, in this, the petitioner is before this honorable court wherein a maintenance of 40,000 has been ordered from his salary. My lord, the respondent herein is getting 60,000 from the parents of the petitioner in the very case, and every month he's getting 60.
Parents of,
The petitioner.
that is from the father-in-law and mother-in-law.
Yes, my lord. She's getting every month 60,000. The whatever is the maintenance that she's asked for.
How much she has?
She asked for 60,000 of maintenance and 20,000 for legal expenses. Every month on record to her bank account, she is getting 60,000 from the father-in-law.
Is it brought to the notice of the court?
Yes, my lord. Even in subsequent.
Having stated so, apart from that 60,000, she wanted another 60,000.
Yes, my lord. Now she was working and she's left her job now, and she has a son, and she's getting 60,000.
Children are there?
One son, my lord. He's studying in probably
So how much is granted now?
40,000 is granted, my lord.
What is your salary?
1 lakh, my lord.
Let's see the order. All that was disclosed before the court?
Yes, my lord, that they had prior this one, but I couldn't file the history.
No. About your parents giving her.
Yes, my lord. It is even agreed upon by her that she received 60,000. Even the bank statement was provided before to the honorable court of the money being transferred to, and she agrees to it that she gets every month 60. Father-in-law and mother-in-law.
Let's see what is the finding of the court. Para 13. Para 13 of the order.
Continue.
Read it.
Though the petitioner has filed this petition for divorce, it is his duty to maintain the response. There is no contention of the petitioner husband that he is paying maintenance amount of 60,000 per month to his wife, and no document is produced before this honorable court in this regard. So the applicant wife made out prima facie are entitled for.
So the issue is about payment of 60,000, there was no material before the trial court.
Yeah.
That's the thing. So what did you file? To show that she's receiving.
Subsequently, we have filed the bank statement and everything that she's been paid 60,000 per month.
Place that before this court, we will see.
Yes, my lord. This one may be stayed, and I'll pay any amount that is being prescribed by court will be deposited before the court, my lord.
What is the age of the child?
He should be in 11th standard, my lord, probably 16.
What's wrong in granting 40,000?
No, he's taking care of the fees and all, my lord. The father.
What is that finding?
The father's taking care of the fees.
That's what, where is the finding that we have to understand from this?
I will file that before this honorable.
That's why you file whatever Monday. Pose this matter.
Wednesday, my lord.
Huh?
Wednesday.
At the request of non-counts for the petition, pose this matter on Wednesday.
Much obliged. my lord.
Yes, fine.
5, Sharad Gowda ji.
I'm seeking enhancement of interim maintenance that was granted by the family
Was
court.
seeking enhancement,
Enhancement.
notice,
Lord,
petition is permitted to take out
Lord,
notice.
the husband has also filed a petition
Or what is the
telling the
number?
order. That is WP number 18280 of 2024.
Post along with so and
Yes.
so on September 23rd.
Please, ma'am.
Yes, next.
6, VP Sidramaya.
Yes.
Well, the respondent has filed earlier CMS number 378 of 2013. The same was dismissed by the order dated 13/2 to 13/2.
Where is the impugned order? Which number?
It was dismissed on 13/2/2004. My lord, against the said judgment, my lord, a revision petition is filed at annexure D, page number 26.
No, please tell the facts. Who are you? You're the wife or the husband?
My lord, petitioner is the husband.
Ah.
Respondent number 1 is wife, respondent number 2 is daughter.
Ah.
CMS number 1, say earlier CMS filed for maintenance has been dismissed
Hmm.
by the order dated 2014.
Again, it's that RPFC. is
RPFC is filed.
Ah.
In RPFC, a categorical statement defense has been taken. The paternity of the second respondent has been denied. At page number, my lord, may kindly peruse at page number 33. That is the operative portion of the order.
33.
Yes, 33. It will start from 32, my lord.
Yes,
33, last para.
yes.
If the respondent succeeds in proving that petition number 2 is not his daughter, then he is at liberty to file application for modification of the order. My lord, in original suit, a an order has been passed for DNA test. We are awaiting for the report, and at very shortly that will be decided. Meanwhile, my lord, they have filed an execution petition for recovery of the amount from the very date of petition. We are ready to pay the amount from the date of the order. That is all the question, my lord. If it is from the date of the petition, I have to pay nearly about 18 lakh to 20 lakh. That is one aspect. Secondly, if the paternity of the child is, I am able to prove it in the original suit, then I cannot go for recovery of the amount. So, with subject to, my lord, the payment of the amount from the date of the order passed by this honorable
When
court
is the date of order?
at page number 26, my lord, 13/2/2024.
How can this order?
This is the High Court order. Page number 26.
What is granted is?
My lord, 5,000 to each respondents at page number 32.
No, as far as the wife is concerned, you cannot seek for it.
Yeah, wife is concerned. For my lord, the thing is, wife also working is the contention taken by the petitioner. My lord,
Whatever it is now, if you want.
my
you have
lord,
to pay the money and all
High
that.
Court does not order from the date of petition. It is just allowed the revision petition, and liberty is given to the petitioner to recall the application with respect to daughter.
When it is not specifically said, we have to assume that it's from the date of petition.
My lord, huge amount, 18 lakhs, so.
The wife you are liable to pay.
My lord, he is getting.
You have
his-
not questioned this order and the revision.
We have not.
It is attained finality.
It is certain
That
finality.
means wife is entitled from the date of petition.
My lord,
And there are no reasons to stay that order.
my lord,
So as far as the son is concerned,
daughter,
we'll record that as far as the son is concerned from the date of order.
daughter.
For the wife is concerned, you have to pay, will not grant stay.
My lord, he is getting 6,000 salary in working in a local milk union.
How much your salary is?
6,000.
Oh.
So paying
Then
18
how
lakh.
court had granted 10,000, why you didn't question it? So that
I
shows,
have to go to Supreme Court, my lord, his financially is not in a position to question that.
but he has to pay ultimately, that order is not questioned.
My lord,
And you kept quiet from that, from February.
my lord, to limited extent, my lord, it was subject to deposit
No,
of some
we have
amount.
to grant stay on some basis.
Some amount of.
Not that, no, as far as this petition is concerned, that order of the learned judge in the revision has attained finality.
Yes, it has sent
That
finality.
this court cannot grant any concession to you in this.
My lord, there is no specific order from the date of petition. So it is a presumption is from date of order is my submission.
Generally, or wherever there is an order, it will be from the date of petition. Unless and until court specifically says that is from the date of order.
That otherwise you will be arrested and you will lose the job also, entire livelihood will be affected, my lord. That is the,
But please understand,
yes,
what
I
is that the
understand.
court can do?
I
Now with regard to your second submission, that it should be from the date of order.
I leave it to
As far
her.
as the wife is
Yes.
daughter,
So
that
this is the circumstances and the difficulties.
we will, but we can't.
Yes, please.
Learn call. No, which order is questioned?
My lord, we have questioned the order overruling the objection filed by the petitioner at page number. Sorry. At page number 25, my lord. Our objection has been rejected. Our main objection is we are liable to pay from the date of the order is the objection we have raised at page number 13, annexure B. And a recovery also from the every year recovery application has to be filed.
Unnecessarily, why the court should interfere in this?
My lord, as far as the daughter is concerned, my lord,
Is it not that the court is in, by passing any order in this, court is encouraging unnecessary litigation?
my lord, my objection has been rejected with respect to
No, while exercising jurisdiction
yes.
under 227, what is the scope of inquiry? Or the adjudication by this court?
My lord, as far as the daughter is concerned, my lord, that it be even very shortly the original suit will be decided. My lord, if I am not able to succeed, then he is liable to pay. That is a different aspect. So just we are
Court
awaiting.
notice will not, as far as
Yes.
the recovery in respect of son only is state.
Daughter.
Daughter, the learned counsel for the petitioner submits that the court had granted the maintenance of 5,000 to the wife, 5,000 to the daughter. He submits that he is questioning the paternity. And already DNA test is ordered and they are awaiting for the
In OS number 36 of
awaiting for
2013.
the report. He submitted that. In the meanwhile, they have filed the execution. And if the entire amount is paid, it will be difficult for him to recover it. Even according to him, the wife is also earning. Earlier, when criminal MC is filed by the wife and daughter seeking maintenance, when it was rejected, they have come before this court. And this court, by order dated
13 to 2024.
by
Page
order
number
dated
26.
13 to 2024, I had passed an order wherein 5 months, 5,000 to the wife and 5,000 to the daughter is granted. It is also observed by the court that if the respondent succeeds in proving that the daughter is not his daughter, then he is at liberty to file application for modification of the order. The petitioner, when he has not questioned the order passed in RPFC number 192 of 2016, dated 13th February 2024, whether the wife is working or not, and working or not, and whether she's entitled for maintenance, those issues cannot be gone into. But as far as the daughter is concerned, considering the submission, this court is passing the following order. One, the petitioner, as far as the maintenance, as far as the wife is concerned, this court is not interfering. Then when it comes to the case of the daughter, the petitioner shall deposit the amount from the date of the order. Next, the petition is permitted to take out notice to the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 18th of September. If the memo is not filed by then, memo is not filed by then, appropriate orders will be passed, post this matter on 23rd. For the time being, an interim arrangement is made. Yes.
Serial number 7, Rupesh Abhi.
Also notice, my lord. Notice and also copy. Yes, please.
You serve.
I will serve, my lord. Also PF also.
Madam, wife petition for enhancement of maintenance, my lord. And 5,000 is awarded in the by order dated, my lord, it annexure.
This notice to the respondents,
Madam.
same, permitted to take out notice on the council. Shall file a memo by 23rd. If the memo is filed, post it on 25th.
My lord, stay of further proceeding for this reason, my lord. Stay of further proceeding for this reason, my
No,
lord.
no.
Immediately after, my lord, my application is.
Let's not stay the proceedings. Let other side come, then we will see. Yes.
8,
Kindly pass over, my lord.
Pass over. Next 9.
serial number 9,
But for the petitioner, madam. My lord, there's a petition of GNWC that was filed by the petitioner husband in the year 2020. My lord, the impugned proceedings was posted for the stage of evidence back in the year 2021 itself. And even to this day, my cross-examination has not been completed, bro. My lord, in the month of September 2023, I filed a petition before this honorable court and I seek for expeditious disposal of the trial proceedings. My lord, it's in Annexure G, page number 97. It's the direction of this honorable court.
February 2024.
That's the date of the judgment, my lord. My lord, if I may take your lordship's attention to page number 100 of the petition. There is a specific. Yes, ma'am.
4 months. Please come.
Yes, ma'am.
On 14 February 2024, an order was passed directing the family court to conclude the proceedings within 4 months from the date of receipt of the copy of the order. Then counsel appearing for the petitioner submits that in spite of a specific order from the court, the proceedings are not concluded. And
My lord, one submission that I would like to place on record is that the copy of this particular judgment that's produced in Annexure G, it was brought to the notice of the trial court on 22/4/2024, my lord.
it is
Thereafter,
submitted that it was brought to the notice of the court on 22/4.
2024.
2024, and still now, in spite of the orders, the court has not concluded and unnecessary adjournments are sought. The learned judge shall place a report before the court.
My
Why,
lord,
in spite of,
the issue is actually with the respondent is not cooperating with the trial
the
court
court is not precluded from passing an order. There is
Certainly.
the judge, family court, so and so, shall place a report before the court. Why, in spite of an order passed by this court dated 14th so and so, 14/2/2024, why the proceedings are not concluded? District judicial is directed to communicate this order, post this matter on Wednesday.
My lord, I have one submission to make. My lord, it's like despite all these directions, despite a specific direction from this honorable court to the respondent herself to cooperate with the trial court in the expeditious disposal, the respondent has been taking continuous adjournments even after placing the judgment.
Now, we can't, once an order is passed.
Yes.
Again, another order will not be passed. Now, the trial court, the family court judge has to say why it is not complied with.
Yes.
No other things we can do now. Yes, post this matter on Wednesday.
Kindly.
serial number 10.
Yes.
My lord, before my learned senior colleague could start his arguments, my lord, I just have one submission, my lords. My lords, this matter is referring to 2 loan accounts, my lords. We are willing to settle the loan accounts itself, including the interest part as well. So that is the undertaking which I can also take, my lord, which my client is also taking. So if my learned senior colleague could give us 2 weeks time, I myself will sit with him, with my client, and we'll close both the accounts, my lords.
Story is nice, my lord, but back history is very bad.
I understand, my lord. I'm not.
Record all this.
Please,
my lord.
please.
I'll record all this, what he is submitting.
It may either be referred to mediation or we ourselves will close the matter in the next 2 weeks, madam.
What do you say, mediation or you will settle?
There is,
My
my lord, I really don't understand, my lord, what to submit because from 2014, my lord, 8 crores, 80 lakhs loan was given.
Who is the appellant?
Appellant, my lord, is a cooperative bank,
Cooperative
urban bank,
How much is the amount?
23 crores.
My lords,
After loan, my lord, not even 1 rupee paid.
3 crores from 2014.
my lords,
9 crore 80 lakhs was the total loan paid in the year 2014. Then when he failed, my lord, we proceeded under section 70 of the Karnataka Cooperative Society Act, filed a dispute against him. Award has been passed. No payment has been made. In 2023, my lord, all this new act, Surface Act has come into force. So we are entitled to exercise powers, my lord, under Surface Act. Supreme Court has also cleared it that in respect of urban cooperative banks, this Surface Act powers could be exercised. So we issued a notice, my lord, under section 13(2).
Yes.
No reply. 13(4), we passed a final order, symbolic possession. No reply. Then we filed an application to the magistrate.
What is the property mortgage?
Property mortgage, my lord, consists of about 2 acres of land and a converted, my lord, site property in Sadashivanagar, Bangalore. Then, my lord, we filed an application for, my lord, actual physical possession under section 14 of the Surface Act. He has filed the present suit. The prayer in the present suit is grant injunction against the defendant, cooperative bank, restraining the defendant from taking possession of the property, restraining the defendant
Court has
from.
granted.
Please, my lord.
Court has granted.
my lords,
Court has said, court after holding, plaintiff has no prima facie case, plaintiff has no balance of convenience, no irreparable cost will be caused to the defendant number 1. After holding it, the trial court has granted, my lord, injunction against the defendant. Now he says, my lord, this,
Which
my lord,
court is this?
settlement story.
Where is the order?
My lord, your lordship sees the order, my lord, at
number 16.
page, my lord.
Which court is this?
City
Trial
Police.
court, my lord, page 38 is the impugned order. Findings, my lord, at page 36, first paragraph. If your lordships looks at, my lord, page 36, first paragraph. Looking to the case of the plaintiffs in that angle, the plaintiffs have not made out a prima facie case. Balance of convenience is also not in favor of the plaintiffs, and irreparable injury will be caused to the defendant number 1.
According to him, now the new law is when all the 3 of them are not there, then injunction should.
My lords, if my
Not even 1 rupee paid, my lord, from 2014.
No,
They go on
once-
saying, we will settle, we
once
will
surface
settle.
proceedings are initiated, why the court had entertained this?
It could
suit?
not have, my lord, it has no jurisdiction.
Easy alleging any fraud and other things?
yes, my lords, we are alleging.
What is the fraud?
Now
Let
you
him say,
have
my lord,
to-
what is the fraud? One sentence, my lord, fraud requires particulars. What is the fraud? Award is there against him long ago. He has not filed appeal. I am asking that award amount recovery.
My lords,
What is the fraud which is saying?
my lords, my only
Fraud is I am bringing the property for auction.
my lords, my only submission is that my lord, if my lordships may turn to page number 36 of that order itself. I've made the same undertaking here also, my lords, wherein I'm willing to settle the matter.
6
My lord,
months have lapsed
the-
from the date of decree. You could have sold it now.
my lords,
Will not entertain any of it. We'll hear it.
My
from
lords,
the- No,
my lords,
already you had the benefit of,
No.
approaching
my lords,
several courts.
it may be posted on Wednesday, my lords, my senior counsel will, it may be posted on Wednesday, my lords.
Pose this matter on Monday on the top of the list.
Serial number 11.
Plaintiff's
Yes.
appeal, my lords.
Yes.
Appeal against rejection of TI restraining the defendants number 2 and 3 from alienating the properties.
What is the suit for?
Suit for declaration, possession, mandatory injunction, and also permanent injunction. My lords, when the suit was filed, my lords, may I pass on some certain documents which are placed before the trial court, my lord, for the sake of convenience. For a copy. Please. Lords, before adverting into merits of the case, my lords, I just want to point out, your lordship may kindly take the order sheet pertaining to the suit proceedings.
that your lordship will get,
From your, this papers or this,
yes, page 159,
from the MFA?
documents which are now,
Yes.
page 159. This is the suit. (159)
Yes.
OS 577/2023. My lords, this suit is filed on 23/1/2023.
Yes.
Your lordship takes it. My lords, at next page, page 160. Initially, my lord, the suit is filed only as against defendant number 1. Defendant number 2 and 3 were not parties at that point of time. That
Yes.
is only against T. Nagraj. Defendant number 2 is son of T. Nagraj. And defendant number 3 is a developer. Initially, suit is filed only against defendant number 1. This defendant number 1, your lordship will kindly see at page 160. He undertakes that he will not alienate or create third party interests. Your lordship got it, names.
Which defendant has said so?
The first defendant, T. Nagraj.
Yes.
This undertaking is on 3/2/2023.
Yes.
After giving this undertaking, my lords, he keeps on taking adjournment without filing objections or written statement. At page 162, your lordship will kindly see.
Yes.
This undertaking, which was given for limited period of till filing of the objection, is made till disposal of that IA for
You
restraint.
get that?
Page 162. Page 162, dated 7/7/2023. Your lordship will see. I have filed an application for extension of that application. If an undertaken or given by the defendant until disposal of IA or merits, no hardship will be caused to the defendant herein. Thus, IA number 4 filed on 151 is hereby allowed, and it is extended till disposal of IA.
Yes.
It's initially undertaking was given on 3/2, as I pointed out, 3/2/2023. What this defendant has done, even before giving this undertaking, he had gifted this property in favor of his son, playing fraud upon the court. On the date when he was giving undertaking, he did not disclose that he has already gifted the property in favor of.
Gift is not alienation.
This gift deed, your lordship will get a document number 18, page 113. That is on 27/1/2023. Page 113.
Gift deed was dated 27.
1/2023. The undertaking is given on 3/2/2023. Therefore, just 7 days before he gives this undertaking, he has executed, already divested his right by way of this gifted in favor of his son. He doesn't disclose this. Then his son has entered into joint development agreement with third defendant on 1/6/2023.
1/6?
2023. That is at page 123. JDA from Karthik. Karthik is the son of defendant number 1. He has entered into joint development agreement with JD developers, page 123, 1/6/2023. All this while they don't file return statement, they keep on, we get this extra undertaking getting extended without knowing that there is already creation of third party rights.
Yes.
Then ultimately, one fine day, he files an application to recall because return statement was not filed. He did not file return statement within the statutory period of 90 days. One fine day, he files return statement. There he discloses about this gift deed. Immediately, we file an application for impleading D2 and D3. That application came to be allowed. And as against D2 and D3, we also file an application restraining them from alienating the property.
That IA?
IA number 10 and 11. On that IA also, at page 166, if your lordship sees.
166 of this document.
Yes. Everything of these documents. Only plaint and return statement is there along with the appeal memo papers.
166.
Yes, my lords. Your lordship will kindly come to page 166 and see the order dated 28/8/2023.
166.
Yes. Ink page.
26/8/2023 order.
Yes. D1 and D2 files memo of undertaking stating that D1 to D3 will not alienate and create encumbrance on suit schedule B property until disposal of IA number 10. Therefore, this was there till disposal of IA number 10 also. Now IA number 10 is rejected. This is the stage, my lords. Firstly, on conduct.
Understood.
On
Please come to
conduct,
the-
I am entitled for, my lords.
Yes.
On conduct, I am entitled for a not to alienate because it's an innocuous release. So far as construction, they have constructed. Let them not alienate is the limited innocuous relief I am seeking as I had this benefit throughout the suit proceedings. Also, the D1 had suppressed the fact he had already created gift deed and also JDA by D2 to D3 and they have played fraud upon the court. This conduct itself will entitle me for injunction. This is my first argument. On merits, my lords. Now, my lords, the plaintiff is claiming to have purchased these sites from the landowners of survey number 242.
The sale deed is dated 26/7.
On the other hand, 242/1 of Halage Vaderahalli village, Kengeri Obli, Bangalore South Taluk. I will later on explain the title flow insofar as the plaintiff is concerned. My lords. Your lordship may kindly see this.
Yes.
So far as defendants, they are claiming that their vendor was allotted with a site by Vishwa Bharati House Building Cooperative Society in survey number 242/1. Therefore, my lords, on one hand, the defendants are claiming through the society, sale deed executed by the society.
No, before that, what is the source of your title?
Source of my title, my lords. One Fiaz Khan was the absolute owner of 2 acres 29 guntas of land in survey number 242/1. This Fiaz Khan sold survey number, the entire extent of 2 acres 29 guntas in favor of one MR Deepak and Shashikant Rao under registered sale deed.
Yes.
After this, my lord, Shashikant Rao and MR Deepak got their names mutated in the RTC as well as and they paid taxes and they got this land converted from agricultural to non-agricultural purpose. Out of these 2 acres 29 guntas, a converted extent of 18 guntas was sold in favor of one Vijay Shankar under registered sale deed. Out of these 18 guntas, Vijay Shankar, who is none other than my husband, he has formed a private layout consisting of sites and gifted site number 5 and 6 in my favor. I am having
Your husband had purchased this 18 guntas of land.
18 guntas of land.
And in that, what has he gifted you?
Yes, he has formed a private layout consisting of sites. He has gifted site number 5 and 6.
That's a dispute, that's a suit schedule property.
That is the suit schedule property. 4 and 5.
Measuring,
4 and 5. I stand corrected. 4 and 5.
admeasuring?
Admeasuring. I'll just give it. Admeasuring, there are two sites, my lords. One site, site number 4, is measuring east to west 30 feet, north to south 45 feet, in total 1350 square feet. That is item number 1 of the suit property.
5.
Site number 5 is east to west 30 feet, north to south 45 feet, totally measuring 1350. Again, same.
1350.
Both sides, same measurement.
Yes. Now, what is the case of the defendant?
Case of the defendants, my lords, one Vishwa Bharati House Building Cooperative Society, my lords, it intended to acquire various lands, including the survey number 242/1. Accordingly, my lords, notification was issued by the state government under section 4(1) of the Land Acquisition Act. After issuance of section 4(1) of the Land Acquisition Act, the state government did not issue section 6(1). No final notification was issued. This society filed a writ petition before this honorable court directing the state to issue 6(1) notification. This court said this is the duty of the state. We will not direct the state to issue 6(1) notification, whether it is for public purpose, whether so we will not issue. It only said if at all you are entitled, you go take back the amount which you have deposited for cost of acquisition. We are not going to direct the state government to issue 6(1) notification. Your lordship may kindly see that order of the writ petition, which your lordship will get at page 1 to 3.
Yes.
Page 1. WP number 18584 of 1989. This is this petition filed by Vishwa Bharati House Building Cooperative Society of the documents, my lords. Page 1 of the documents.
That's in the year 1996.
1989. The order is 1996.
Yeah.
The High Court dismissed the writ petition, said para 3,
Refund the same to the petitioner.
refund the cost of the acquisition. The society filed writ appeal.
What does happen?
That is page 4, writ appeal 8766 of 1996. Writ appeal also came to be dismissed, confirming the judgment of the single judge.
So according to them, from Vishwa Bharati, when did they purchase?
1996.
19?
Their sale deed is dated. I'll give the exact date of the sale deed. 1/6/1996 is their sale deed.
1996. Writ petition order is?
Writ petition order is 27/8/1996.
27/8/1996. Appeal order is?
Writ appeal order is 4th December 1996. In spite of this, during the pendency of the case before
What
this.
you are submitting is, now the land that has to be acquired for which that Vishwa Bharati Trust had paid the amounts is this piece of land.
Yes.
Apart from other lands.
Other lands. So the acquisition itself is not complete. There is no final notification as such. Now thereafter, the society has gone ahead and taken back the amount which are deposited for cost of acquisition, therefore accepting the judgment of the single judge as well as the division bench, and taken back the amount by executing a registered indemnity bond. Your lordship will get a document number 3. 18th July 1998, it executes indemnity bond because the acquisition did not fructify, takes back the amount, cost of acquisition amount which was paid. Therefore, these documents make it evidently clear there is no acquisition in favor of the Vishwa Bharati House Building Cooperative Society.
Your husband's purchase was when? The gift deed was in the year 2020.
Yes, my husband purchased this land. On 12/8/2020, 18 guntas.
After that, he has executed the gift deed in favor of 4 and 5 plots.
Yes. My husband had purchased from the S12 owner, that is Deepak MR and Shashikant Rao, under sale deed dated 12/8/2020. This Deepak MR and Shashikant Rao had purchased from the S12 landowners under sale deed dated 26/7/2011 itself.
Yes.
S12 owner is one Fiaz Khan. The land got notified in the name of Fiaz Khan. That I have produced preliminary notification as well to show. The land got notified in the name of Fiaz Khan under section 4.1, but there is no section 6.0 notification.
Same plot number, no, even according to them, they purchased plot number 4 and 5.
No, the society gives a different layout.
But the identity of the land
same
is
property. We are disputing for the same property, my lords, or else you will not be at
Please come to
loggerheads.
the order.
My lords, before that, my lords, I have to submit 2 other facts. What they try to do now is in the written statement, they do not say anything about these acquisition proceedings. Before these acquisition proceedings, there is a GPA said to have been executed by the landowners in favor of the society. That is of the year 1986. This GPA was only to enable the society to get the section 4.1 and 6.1 notification. It is not this, my lords, because this GPA is not coupled with
the GPA.
My lords, this GPA, your lordship gets the GPA at document number 15, page 86. This is prior to initiation of acquisition proceedings.
1 minute. 86.
Yes. This GPA is not accompanied by affidavit or agreement of sale.
Let's see what are the contents of the GPA.
Please.
In Kannada. What it says, just one page.
I'll just try to translate it to the best possible. Our sale detail. Lord's General Power of Attorney.
Come to the relevant, what are the terms of it?
Sadar is, the society is entitled to get the kata of this land in its name. It is entitled to farm layout and sell. That is what is the content, just content of this GPA. But your lordship will kindly appreciate, this GPA was dated 11/9/19.
In this GPA, where do you get about this acquisition?
There is nothing about this acquisition in
So your husband's vendor's vendor is also one of the, he has executed this GPA.
They claim that he has executed this GPA. This is in respect of entire 2 acres, 11 guntas in survey.
They have no that Vishwabharati Trust. That
Vishwabharati Trust. Two things come here. So far as this Vishwabharati, it's not a trust, my lords. It is a house building cooperative society. So far as cooperative society is concerned, there is a bar of acquiring agriculture lands under the Karnataka Land Reforms Act, section 109. So societies cannot purchase agriculture lands, if I can.
That aspect will not go into this now.
Okay.
Yes.
Anyways, the only mode by which a society can acquire an agriculture land is through the state government by way of issuance of notification. Apart from this,
the registered GPA.
No, this is an unregistered GPA. This is an unregistered GPA of the year 1986. We are disputing this, but I'll have to be fair enough to bring to the knowledge of this honorable court how they are trying to claim title. Well, if at all this GPA was in existence, my respectful submission, my lords, subsequent to this GPA, there was no need, if they could acquire land under this GPA, there was no need for the state to initiate acquisition proceedings and the society to agitate that this acquisition proceedings be completed before this court and as well as taking the matter up to division.
Come back to the order in the.
Please, ma'am.
Of the division bench order or the.
Single judge order, my lords. Page 1.
Para 2.
Your lordship is referring to writ court order, my lords. Page 1, my lords. The petitioner in this writ petition has sought for a direction to the state government to complete the acquisition proceedings.
Where is the reference to the survey numbers or anything in any of these proceedings?
Lords, I can only show it by way of your lordship may kindly take para 2 here. It is submitted that the petitioner
that I have seen
has issued notification in respect of section 4(1) of the Land Acquisition Act.
The 4(1) notification.
Yes, I have the 4(1) notification. From that I can show this. 4(1) notification.
No index to these papers?
May I pass on this, I'm sorry, I have not filed along with this in Kannada. Survey number 242. Yes. 242/1. Well, I have rounded off it in Kannada. I hope my senior counsel does not dispute it.
Yes.
This is in the name of Fiyaz Ahmad bin Muhammad Khan, 242/1. That is what is in Kannada. And the extent is 2 acres. I have rounded off it in pen miles. That is Fiyaz Ahmad Khan is the erstwhile landowner. Survey number 242/1. Extent is 2 acres, 11 guntas. The same extent which we are. This is notified.
Give it to him.
Therefore, my lords, if at all this extent is already purchased by under a GPA, there is no need of issuing this 4(1) notification and the society agitating the dishonorable court to issue 6-1 notification and failing before dishonorable court. Now your lordship may kindly see the sale deed. If the sale deed refers to GPI, my lord, they have some semblance of right. Definitely. But the sale deed is silent. Your lordship may kindly take the sale deed, which is along with the documents at page 89, document number 16.
'89.
89. Your lordship got this notes. This is on 1st June 1996, Vishwa Bharati Society, so and so, represented by so and so, in favor of one NG Jayanti, wife of Nagendra, so and so. This is all the sale deed. Does not refer, and your lordship may kindly come to page 90.
I'm looking at that.
Absolute owner in possession of various.
They are referring to this writ petition number is the same one.
Yes, yes.
In view of the judgment exempted from the purview of section 20 of the ULC Act, in view of the judgment of the High Court of Karnataka.
No, different judgment they are referring.
What is that?
That is about Land Sealing Act.
No, in that land sealing act, this survey number is also there.
No, my lord, that is a general judgment on the issue of land sealing things. They are referring to that judgment, and somehow this is how they play fraud, my lord, these societies. In fact, my lord, in so far as state of Karnataka, during this period, my lord, 1986 to 1990, what happened, my lord, these house building cooperative societies mushroomed all over the city of Bangalore. Then, my lords, the state government appointed a committee under the chairman of GVK Rao, my lords, to go into the legalities and illegalities of this acquisition of land for the benefit of the society. What was found out, my lords, this society had created fictitious persons as members of the society, and ultimately the committee gave a report, no, you cannot purchase the land of another private person and give it to another private person. There is no public purpose in that. And ultimately, my lords, it gave a report. On the basis of this report, in 1991, there is a full bench judgment of this honorable court where it quashed the entire notification in favor of various societies, holding that there is no public purpose, and the agreements, GPAs entered by this society with the middleman to influence the state government to issue 4-1 and 6-1 notification are all opposed to public policies. Therefore, this acquisition based on these agreements which are opposed to public policies serves no public purpose. And this matter reached up to Supreme Court. Supreme Court, my lords, went a step ahead in 1995. It's again a reported judgment in the case of Narayan Reddy, said, my lords, irrespective of the fact whether the landowners had approached the court or not, you give back the land to the landowners subject to their repaying the compensation amount. In this case, so far as we are concerned with Vishwa Bharati, there is no 6-1 notification at all. I'm speaking about those notifications. But this is the sale deed which they are trying to.
Yes, come back to the judgment.
Now, my lords, before this, another important fact which will have. This defendant, T. Nagraj, had filed a suit, my lords, as against my vendor, MR Deepak.
Defendant number 1.
Defendant number 1. That was a suit for bare injunction.
Which year is that?
That suit is
OS number?
OS number 2236. One minute. OS 2236 of 2013. Well, during the pendency of this case, this MR Deepak, who are vendors of my husband, they entered into litigation with the council who was conducting their case. Therefore, my lords, this 2236 of 2013, though written statement was filed, there was no contest in form of leading evidence or cross-examining the plaintiff or adducing any evidence on their behalf. Therefore, a decree was passed granting injunction on
3rd October 17.
3rd October 17.
What is the stand of your husband's vendor in the written statement?
In the written statement, we contended that there is no acquisition which is completed. Therefore, the society had no title. The sale deed is non-est in the eye of law. Society could not have sold the property in favor of.
No, the court, while granting this injunction, decree of injunction, just like that granted or basing on some.
No, it's because we had not adduced evidence, it granted the decree. Therefore, we filed RFA. In RFA number 848.
Who filed it?
We filed, my lords. The,
848.
my vendor. Your lordship will get that RFA.
848 of 2000.
845 of 2018. Your lordship will get that at page 35. Appeal memorandum, page 26. Lordship in the list of documents.
Yes.
Your lordship may kindly, since your lordship asked me this question, my lords, at page 30, your lordship may quickly glance to the grounds which have been raised in the appeal memorandum. This was filed by Deepak Kemar and Shashikant Rao, who are the vendor of my husband. And ground 11 at page 31. No doubt the defendants have not adduced evidence in support of their conduct, but in the facts and circumstances, the trial court ought to have considered the pleadings and the ascertained in the light of the detailed written statement filed by the defendant as to whether the plaintiff has made out a prima facie case to title. In the absence of said excess, the impugned judgment and decree suffers from illegality and irregularity, cause for interference at the hands of. These were the grounds. And page 15, I am referring to all these writ petition and writ appeal orders. Then lords, this appeal has been admitted on
no pending consideration.
It is admitted and pending consideration. 7/11/2019 is the date of admission. That is at page 35, document number 10.
I've seen that.
Now, in the impugned order, the society, my lord, the trial court, I'm sorry. The impugned order, your lordship will get at page 20.
Come to page 35, paragraph.
Page 25, my lord.
35.
35. Yes, minutes.
What is the Schedule A property?
Schedule A.
We sought for non-alienation in respect of B. That is plot number 5.
4 and 5, 2 sides.
Lords, I already said, my lord, there are gifted in respect of 2 sides.
4 and 5 is said.
Schedule A is one of the sides and Schedule B is another side. Huh? I'm sorry, my lords, I'm sorry. Schedule A, it consists of item number 1 and 2, which are the 2 sides which are gifted to me. And this Schedule B property is the site claimed by them, which couches and overlaps with my sites. Therefore, for purpose of identification, Schedule B is the boundaries as well as the measurement as given in their sale.
No, there is some confusion in that. No,
My lords,
the entire suit, you are seeking declaration in respect of which property? 4 and
your
5.
lordship may kindly take the plaint, my lords. It will just
Page number.
Plaint starts at page 64.
Come to the schedule of the property.
At page 73, my lords.
Third side bearing number 4, bearing number 5.
Next
They are
page,
item
my lord.
number 1 and 2 of
That
schedule property.
This is Schedule A property.
And then B.
Schedule B property at next page. This is the site which is claimed by them.
They give the number as 509 according to them.
Yes.
Yes. Only the numbers have changed.
Numbers change, my lords, but we are fighting for this, or else we will not be at loggerheads.
Yes.
If they are claiming elsewhere, then there is no question of fighting, my lords.
Come back to the.
My lords, your lordship in the impugned order, kindly take para 18. Para 18, your lordship got, my lords, at page 42.
Yes.
In fact, the documents produced, particularly the certified copy of the RFA produced, it appears being agreed by the judgment and decree in OS 2236 of 13, have preferred an appeal. Said appeal is even today pending for admission. Prior to the above said suit of the defendant number 1 against the vendor of plaintiff, in fact, the vendors of the defendant 1, Vishwabharati Society itself had filed suit. Where is that? It's pending for admission, my lords. Now, the trial court is influenced by the fact that the appeal is yet to be admitted. But, my lords, I just now pointed out that appeal has already been admitted. Lords, two things have swayed in the mind of the court, my lords. One, this decree which was suffered by my vendor, and the appeal filed is not yet admitted is the erroneous conclusion of the trial court. Secondly, the trial court has assumed that on the basis of GPA, title has been conveyed in favor of the defendants, vendor. My lords, if at my lords,
Yes.
by all these documents, my lords, if I question myself, my lords, at this point of time, whether I have made out a prima facie case, definitely I have made out a case for trial, my lords. Whether there is conveyance of title on the basis of GPA or whether this
Please come to para
GPA,
26.
please,
I mean, page 45.
please.
What is this appeal 45 bottom page?
45 minutes.
Bottom of the page.
In fact, the appeal, the Honorable High Court of Karnataka was pleased to upheld the decree against which. My lords, I'll just read this paragraph, my lords, to get an idea of what.
For that, you have to come to page 44. In between, in judgment of OS number 2355.
Lord, this society had filed a suit against the CMC to direct the CMC to effect kata in
What is
respect.
CMC?
City Municipal Council. The which of before this BBMP, expansion of jurisdiction of BBMP, Bangalore Bruhat Mahanagara Palike, it was earlier the town municipal and city municipal councils of their respective jurisdictional councils. They had.
Sorry, page 43, top, your lord, ladyship will get the background of the suit. Page 43, third line.
Oh, the society had filed a
The vendor's vendor.
mandatory injunction directing this council to issue kata. No. To issue kata.
Mandatory injunction directly chief secretary.
Mutate the kata of size purchased by the purchaser carved out in land bearing.
Government of-
Yours is survey number?
242/1.
242/1.
But the 242/1 is not there in this. If you look at page 43, you will find only 242. 242/2/1 is
Your
not.
lordship will kindly appreciate, in this suit, we were not parties, the land owners who are the.
Ultimately, what has happened?
My lord,
No.
this suit came to be decreed. We filed appeal. Some of them filed appeal. There is. My lord, sir.
TMC had stopped to mutate the kata of the said site in favor of the persons who have already got the sale deeds from the said society. In judgment at voice number, read from page 44, middle of the page. In a
44
judgment
middle
of
of the image, my lords, please. In judgment at OS number 2355, the commissioner of CMC, Rajan, he himself got examined as DW1, who had categorically disposed that he has visited the layout of Vishwa Bharati, formed in the above said land, found that it's fully developed, roads have been built, drainage and electricity, water connections have been laid. Even CMC had issued kata in favor of the purchasers of the sites in the said layout, but he contended that as the divisional commissioner has passed an order restraining to mutate the katas of sites purchased in the layout formed by the above society, they have issued an endorsement by refusing to mutate the kata. But the court in the case filed by the above society decreed the suit by holding that the divisional commissioner had no opportunity to issue such direction to CMC. Raja Rajeshwari, in turn, decree for mandatory injunction is issued to the said authority to mutate the katas of the sites in favor of the purchasers in the layout formed by the society. In fact, in the appeal, the Honorable High Court was pleased to uphold the decree. Lords, this is an erroneous finding because I am having that appeal. What happened, my lords?
No, we cannot say that it's an erroneous finding. The appeal, High Court has confirmed.
No, I'm not saying. High Court has not confirmed. That is what I'm saying.
Upheld the decree.
No, there is no appeal reference here.
No, next, that's what the court says.
No,
in fact, in the appeal, the Honorable High Court of Karnataka.
I'm having the appeal copy, my lords. This is an erroneous finding. There is no upholding of the decree in the High Court. Your Lordship will kindly, this suit was filed only against the authorities of the state. The private landowners were,
According to you, what happened to the appeal?
my lords, the appeal filed by some of the landowners questioning this decree. This honorable court only said this is relating to Kata. Title is not adjudicated. Your appeal is dismissed with proper liberty to file suits for de novo trial. That is all. If I am able to pass on the appeal.
The very document they produced in trial court.
That is the reason, my lords. That the trial court has not mentioned the RFA number also. It only says de novo trial. Title aspects, it has to be adjudicated by a trial court. We'll have to file a suit for declaration of title. That is what we have done today.
To file a separate suit and the status quo to maintain.
That's all. It is not appeal decision as if it is observed by the trial
Yes, sir.
court.
Please come, read further. Para 19.
Well, thereafter, when the BBMP failed to effect Kata, some of them lodged a complaint before the Honorable Lokaayukta. Lokaayukta directed then the Commission of BBMP to look into the discrepancy in mutating Kata of the site, so and so, so and so. Thereafter, the Commissioner BBMP has issued a direction to Additional Commissioner of BBMP to mediate the Katas of the site formed in the above site. Further, if the document submitted defendants are considered, the society has submitted the details showing that the numbers of the site carved out in the said layout, out of which almost 788 sites have been allotted to the members by executing sale deeds by registering in the office of so and so. And I also issued, BESCOM has also issued details of the numbers of electricity connections given to the site owners in the layout formed by the society. As of in the year 2000, they had given almost 249 electricity connections to the buildings in the site put in the site layout. If the above incidents are considered, the case of the plaintiff is fully doubtful. At the cost of repetition, this court would reiterate the importance of sequence of events taken place as per the documents placed by the defendants to show that the material available, particularly both placed by both sides, are considered. Firstly, it is not the case of defendant number one or the above said society that the society had formed the layout in the land acquired by the government for the benefit. It is their categorical contention that it is that original landowner, including the owner of the land, have executed the GPA in favor of the society, based on which they formed the layout, allotted the sites, executed the sale deed. In their layout, around 60 acres, 900 sites have been carved out between 1986 to 2004. In all, they have sold 700 to 780 sites. Therefore, two things are swayed, my lords. One, my vendor had suffered a decree of injunction. Second, the trial court, my lords, has conducted a mini trial and went on to say that
yes,
the sale is there is conveyance of title in favor of the defendants on the basis of GPA. Though, but for this GPA, agreement of sale is not produced. Affidavit supporting that there is agreement, GPA was coupled with interest was not produced. And why subsequent to that GPA, 4-1 notification was issued by the state government in respect of the very same land is not produced?
Yes.
Lords, at this stage, as I argued in the beginning, my lords, because of their conduct, that the defendant number one, for the father of defendant number two, says he gives an undertaking. Later, after 6 months, he brings to the knowledge of the court as well as to the knowledge of the plaintiff that there is a gift deed. And subsequently, based on the gift deed, there is a joint development agreement. This alone, on plaintiff has made out a prima facie case, balance of convenience lies in his favor. So far as structure, my lords, they have constructed now. Therefore, restraining them from alienation, my lords, is an innocuous relief and for which the plaintiff is entitled for, having regard to the checkered history of the case. Mewaj, 2004. It's last. Now may I relay one judgment, my lords, before my lords.
Take that.
In a similar circumstance, my lords,
Yes.
where the trial court had granted injunction in this case, the first appellate court, my lords, on their submission that they may be permitted to go ahead with the construction, they will not claim equity, allowed such a prayer and permitted them to go ahead with construction and said so far as alienation, doctrine of lis pendens will come into. Because the Supreme Court said, when suit is filed and there is a prima facie case made out, it is always better to preserve the status of the property as it is till disposal of the list. Your lordship may kindly take para 10 minutes.
Yes.
Be that as it may, Mr. So-and-so is right in contending that unless and until a case of irreparable loss or damage is made out by the party to the suit, the court should not permit the nature of the property being changed, which also includes alienation or transfer of the property, which may lead to loss or damage being caused to the party who may ultimately succeed and may further lead to multiplicity of proceedings. In the instant case, no such case of irreparable loss is made out, except contending that the legal proceedings are likely to take a long time. Therefore, the respondent should be permitted to put up the scheduled property to better use. We do not think in the facts and circumstances of this case, the lower appellate court and the high court were justified in permitting the respondent to change the nature of the property by putting up construction, as also by permitting the alienation of the property, whatever may be the conditions on which the same is done. In the event of appellant's claim being found baseless ultimately, it is always open to the respondent to claim damages, or in an appropriate case, the court may itself award damages for the loss suffered, if any, in this regard. Since the facts of the case do not make out any extraordinary ground for permitting the respondent to put up construction and alienate the same, we think both the courts below, namely the lower appellate court and the high court, erred in making the impugned orders. Now, my lords, all that I would like to submit, my lords. I am not pressing my IA on IA number so far as not to change the nature of the property, my lords. That is IA number 11. So far as IA number 10, it's an innocuous relief not to alienate because they have already put up construction, they are in possession. My suit is for possession and mandatory injunction. Now, my lords, through their conduct, as I argued in the beginning itself, my lords, the defendant number, my lords, gives a false undertaking. This conduct, my lords, definitely, apart from the facts which I just demonstrated, that there is prima facie case for trial, creating of multiplicity of proceedings will only lead to serious prejudice. Therefore, let them not alienate. That is all I am asking. And even after passing of the impugned order, my lords, this order was suspended till for a period of 10 days time, so that I can prefer appeal before this honorable.
Yes. Yes, Ms. Sinekon.
No, I beg to appear. Lord, there are three respondents before your lordships. One was the original first defendant, father. Second defendant, second respondent, my lord, was his son. The third respondent is the developer. Now, my lord, a few dates, my lord, will assume some importance. My submission, my lord, is that the order of the trial court does not merit interference because it's not a perverse order. Your ladyship will know, my lord, that in a order 43 appeal, unless it would shock your lordship's conscience as to how the court has dealt with it, or there is some perversity in the order, it does not call for interference. It's the first, not principle. Lord, this suit was filed on 23rd January 23. Lord. The title, my lord, which the defendants claim, it originated, my lord, on 1/6/96, first time alienation. Second alienation, my lord, is 13/2/2003. Neither of these sale deeds, both are registered documents, till today not questioned. They have not even now questioned it. They only say, give me declaration regarding these two sites that I am the owner. These two sale deeds, my lord, they continued to remain operational till January 27th, January 23, when a gift deed was executed by first defendant in favor of second defendant.
No. The sale deed of the defendant had purchased the property in the year 1996.
Yeah.
From Vishwabharat.
No.
Defendant number one in 1996.
No, my lord, defendant, no, lord, that's why I'm submitting, my lord. The first sale by society was in favor of one Srimati Jayanti.
When is that?
That was on 1st June 1996,
No, that's what I'm saying. 1996 is the first sale.
in favor of one Srimati Jayanti. Jayanti sold it to the first defendant Nagaraju by a registered deed of 13th February 2003.
No, he has argued and the facts are before the court straight away, even before you proceed. What is going on in the court's mind is, no, Vishwa Bharati claims title to all these properties or whatever a layout is made by Vishwa Bharati Cooperative Society and sold it to its members. Now they say that the court's finding, one, basing on a GPA that is executed by so-and-so in favor of the society, they have carved out all these plots. And then comes the question of land acquisition with respect to the very same plots. Now, as far as the land acquisition is concerned, now that 4-1 notification 6 and the writ petition order, writ appeal order are all there. Now, what is the source? Now, according to him, the source of title to the property, right from the first one is on 27/7/2000. What is the first sale deed? Yours? First sale deed of your vendor's vendor.
My vendor's first sale deed.
2011.
2011. And thereafter, in 2020, then they formed now, if the court's finding is basing on a GPA, which is an unregistered GPA, basing on that, all this, the
Layout has
Vishwa
been
Bharati
formed.
has got the right to do all these things. Is one. Then court refers to the injunction suit that is filed by no, it's not a suit for bare injunction, it is a suit for declaration. Whoever is in possession, according to him, he claims that he is the owner of the property, which has to be ultimately adjudicated by the court. And prima facie, you could show that this is the line of, that's how the source of title to him. Vishwa Bharati's case, on the face of it, saying that we have acquired the property by way of GPA, and basing on that, you got the allotment, which needs to be adjudicated by way of a full-fledged trial. So why can't there be an order of alienation, not to alienate? Why unnecessarily third-party rights should be accrued?
Yes, I
It's
understand.
the only question.
That is a submission what the other side has made.
No,
I'll
you're looking at the documents.
Yes, my lord. I'll demonstrate, my lord. That approach is, my lord, with due respect, I'm submitting quite erroneous. The reason is this, my lord. A person who comes to court, he has to prove his title. The defect in the title of the defendant is no answer for him.
Yes.
He is saying that I am the owner of this property and therefore I want to protect my right and possession. Admitted position, my lord, is he is not in possession.
Yes, that's an admitted fact.
Because he is not in possession, and from when he is not in possession, it becomes important. Because he claims, my lord, the interim order to say don't put up construction. Then, my lord, construction is going on.
That cannot be granted.
It is completed. So therefore, he doesn't pursue that. Now, my lord, let us examine what his case is, my lord, and see whether prima facie it is merits acceptance. The trial court has come to the conclusion, prima facie the case he has made out does not merit acceptance. I don't have to prove my title as defendant in a declaration suit. It is for plaintiff to
The
prove.
court will do it.
Yes.
In the course of
My
trial.
title I need not prove. He has to prove his title to show that this land, he has a better title, therefore he must be declared as the owner. Now, my lord, that's why I was trying to point out, what is important is, from 2003, there is a registered deed in my favor. Section 3 of the TP Act says if there is a document which is registered, it's public notice to everybody. No difficulty with that. 2023 January, I give a gift in favor of my son. No dispute about that also. They file a suit, my lord, on 23rd January 23.
So when you submitted before an undertaking was given before the court, that will not alienate.
Yes.
Was
If they
that
made me a
fact-
defendant, and if they ask me, don't alienate, if I say I don't alienate a property which I don't own, I'm not committing any fault. They should have
Why-
taken care.
But where is the question of you saying that you should have said, I am not the owner of the property?
Not party on that day, he was not assisted by counsel. He appeared in person. The order sheet shows that.
No, all the more reason you should tell the court the fact
No,
that
but
he
the
is
thing
not,
is-
I have already executed.
No, my
a
lord, but the
guilty-
thing is, if he made a statement, my lord, that he will not alienate. Question is now, my lord, The conduct of the plaintiff is relevant for grant of injunction, not the conduct of the defendant. In this case, if the defendant made a statement that I will not alienate, he meant I will not further alienate.
Anyway, he cannot because it is
It's
his
already
son
gifted.
who is the
That's
owner of the
right.
property.
That's right. He will ensure that he doesn't alienate it further. That's what he's saying. Why should he not? There's no obligation on his part to educate the plaintiff that no, I'm not the owner. You filed a suit against wrong person. Go and file a suit against somebody else. That's not the purpose at all. Why do you expect him to do all those things? He appears before the court. Court says you don't do anything. All right, sir, I won't do anything.
So when you're coming, it's not about you helping the plaintiff.
Yeah.
When a party is before the court,
Yes.
to the court, when he's making a submission, he should be fair to the
No,
court.
he says I'm not alienate.
Anyway, he has no right to alienate because he's not the owner of the property as on
That's
the
all
day.
right, my lord. Even if he doesn't have right in the property, if the court asks him, don't do anything, and if he says, yes, sir, I won't do anything, why should he tell the court that I don't own the property, I've given you the gift deed? All those things are irrelevant. That's my submission, my lord. The conduct of the defendant is of no relevance so far as the grant of injunction against the plaintiff, for the plaintiff is concerned. Lord, kindly appreciate this. He was not assisted by counsel. He appears and the court says, don't do anything. He says, oh, sir, I won't do anything. That means he didn't do anything. Did he do anything? If he has done something after that, then it's a violation. Then, my lord, he can be pulled up and contempt action be taken. No action for contempt is taken. Till now, my lord, I subject to correction. Even in the appeal memo, this is not raised. They don't say anything about this. This seems to be, my lord, an argument which is now, my lord, because they don't have anything on merits, they're trying to do all these things, trying to prejudice the mind of the court. That should not happen.
That can't be a basis to grant injunction. I'm asking.
Yes.
Because you're appearing on behalf, I'm asking what is the submission?
The submission is
Whether
this.
on such a submission, injunction is granted is not, that's not we are debating
No,
here.
what I am submitting, my lord, is the submission that he made cannot be treated as a misrepresentation. The question posed to him is, don't do anything. He says, yes, sir, I won't do anything. And he has not done anything. Whether he could do, he could not do, is a different matter altogether. That has nothing to do with it. That's my submission.
Yes.
And that can't be put in the weighing scale to grant an order in favor of the other side. Therefore, my lord, and that is not raised anywhere in the appeal. I was really taken by surprise. Unless I missed
I'm
it.
sorry, para 30.
Very good.
The senior Messi, para 30. That is the ground specifically raised.
Yes.
Then,
That
my lord,
the defendants have played fraud upon the court and trial court failed to appreciate this conduct of the defendant playing fraud upon the court, which would entitle me for grant of
Yes.
very well, my lord.
Yes.
Now, my lord, I'll go to the case of the plaintiff. Now, my lord, the case of the plaintiff is that one Fayaz sold survey number 242/1 on 26/7/2011 to one Shashikant Rao and Deepak. This Deepak and Shashikant Rao are supposed to have made a layout in 18 guntas and sold that on 12/8/2020 to the plaintiff husband. That is the case that they make out. Now, my lord, from 2020, did they take possession? Because admittedly, they are not in possession. Who was in possession? What is the document to show that this Shashikant and Deepak made a layout? Did they get any approval from any authority? Did Panchayat approve the layout? Did local authority approve it? Was there a POD done? Who prepared the road? Nothing. Just a document in 2020. And 2020 onwards, they don't do anything. Now, my lord, in the meanwhile, what happens is, in 2013, a suit is filed in 2236/13 against Deepak and Shashikant. My learned friend, my lord, has not produced a copy of the judgment, and I would request permission, my lord, to place it for kind permission. Please see.
No, that is filed by Deepak against whom?
No, filed by me, first defendant.
That is 2017.
Yes, 2017 order. The suit is filed in 2013. At that time, my lord, the first defendant Nagaraju was in possession as the owner of the property, having acquired it 10 years earlier. 2003, he acquires it. He is in settled possession. Nobody comes to disturb him. He's got a compound. He's put a shed there. People are staying there. He's watch and ward. 10 years, nothing happens. Suddenly, this Shashikant and Deepak come to interfere with him. It is before their sale, my lord. Their sale was in 2011. Just after that, they come to interfere. At that stage, Nagaraju files a case. And please see, my lord, what is it that the court does in that case? The judgment is before your lordships. Para 2. Plaintiff has contended one Vishwabharati house building has formed a layout to an extent of 63 acres in Sachidanand Nagar in so-and-so phase, in so-and-so village. The said society, after formation of layout, provided infrastructure to layout by providing
So
electricity.
what is this confusion with regard to this 242/1, 245, 242/2? Now, if you see,
Lord,
if you look at this judgment, it refers to 242/2. Now, they file a suit for declaration in respect of 242/1.
Yes. Now, my lord, my case is that this forms part of 242/1. That is my consistent document. Everything is clear so far as I am concerned. If they are confused, my lord, they must explain to the court what was the subject matter of the proceeding before the High Court, why 242/1 was not mentioned there, what are the extent of 242, what is sub number, when was it sub number given, all that they have to explain. And that is their burden, which I am sure, my lord, they'll try to explain in the course of the trial. But at this stage, there is a judicial order now.
No, this is a suit filed by you.
Yes, my suit. In my
Your
suit,
suit, you say, you speak about 242/2.
according to me, my lord, the site, the property, my lord, which I am claiming is 242/1.
No, look at the case of the plaintiff in the suit. At
That is, I'm talking, my lord, that last line, your lordships are referring to page 2, last line, my lord. What I'm saying is, total 63 acres are there. The 63 acres are comprised in survey number 212 to 242/2. This is the whole two.
Yes.
That's the whole bunch.
Yes.
Totally 63
No,
acres.
I was looking at it as 212 and 242/2.
No, no, sorry.
Yes.
It's 242 up to that is. So that is the whole bunch.
Yes.
Then, my lord, kindly go to page 3.
Yes.
The said society, after formation of layout, provided infrastructure to the layout by providing electricity, sanitary, water, roads, etc. It is submitted, plaintiff has purchased suit property from one Srimati LG Jayanti under registered sale deed dated 13/2/13.
Sorry.
Sorry. May I continue reading?
Yes, sir.
It's submitted, plaintiff has purchased suit schedule property from one Srimati LG Jayanti under registered sale deed dated 13/3/2013. Earlier, the above society had executed registered sale deed in respect of scheduled property in favor of NG Jayanti, who is the vendor of the plaintiff. It's submitted thereafter, Kata has been transferred to the name of plaintiff. Plaintiff has been paying taxes regularly to the concerned authority in respect to suit scheduled property. Now, my lord, if I can just pause for one moment. The litigation, my lord, instituted by society against the government, chief secretary to government, and the city municipal council. Their case was that I have this land, I made a layout, I have complied with everything. These people are not giving me kata, it should be given. That was their case. The suit was decreed after contest, both by the government and by the CMC. In appeal, my learned friend just now brought to your lordship's kind notice. The appeal court, this honorable court, entertained the appeal, and they said, we can't interfere with this order, but we're leaving this question about who is the owner of which property, etc. That appeal order, my lord, comes several years later. But at the time of 2013, which was 10 years after I acquired, I was in possession for 10 years. The position was, I had all the documents in my favor. I was in possession. I had a kata. I was paying tax. And when they tried to interfere, I go before the honorable court. Now, my lord, please see. It is submitted on 9/3/2013. Defendants having no manner of right, title, etc. interest in the scheduled property, along with the henchmen, made attempts to demolish the compound wall by using a JCB. Then, my lord, a crime is registered. And defendants, they claim to be owners of 242/1. That is what they claim, my lord. Then, my lord, kindly go to the next page. There is a defense file, not that they didn't file a defense. Para 3. They deny the formation of layout. Then page 5, agricultural land, and they talk about fires. the sales affected by Fayaz, etc. Then bottom of page 5, submitted that Fayaz Khan, this is their stand, sold agricultural land in survey number 242/1 to defendants for valuable consideration, registered sale deed dated 26/7/11. Thereafter, defendant applied for conversion, official memorandum issued. Then they go to the problems with this society, etc. Next page, my lord, relates to some more proceedings before various authorities. Page 7, my lord, issue 1, where the plaintiff proves he is in lawful possession. The finding is in the affirmative. I'm not going to trouble your ladyship with reading all of it, my lord. Page 9, para 10, all the documents are referred to. Page 10, there is reference to electricity, other approvals obtained, Gram Panchayat, then there is correspondence. Page 11, in my considered view, contents of the above said documents and evidence are helpful to the case of plaintiff to prove lawful possession of the suit property as on the date of the suit. Defendants have not come forward to cross-examine or to deny the contents. After, my lord, appearing, page 12.
Yes.
If defendant does not appear in spite of suit summons, what should happen? Then court examines that and grants a decree.
Yes.
Now, the prayer in the suit was for declaration and permanent injunction. This judgment is not stayed. There is an appeal pending. My learned friend said the lower court has misdirected in saying that appeal is not admitted, but the appeal is admitted. If that is so, my lord, it's an error. It's inconsequential error. Whether the appeal is admitted or not admitted, so long as it's pending, it is pending. Now, my lord, another important facet is this aspect of the matter has been examined by the lower court. Not only this, the lower court has examined other issues also, my lord. There were other suits that were filed. There was one suit, my lord, filed by the plaintiff herein in OS number 7728. My lord, please go to the appeal papers at page number 22. That is part of the order. He first files a suit for permanent injunction and temporary injunction is sought. When that is pending, he files this suit. Then that suit is dismissed.
Against
Me.
very same defense.
Yes.
Withdraw it.
Page
Not
22.
dismissed.
Yes.
I withdraw it with liberty to file a comprehensive suit and file the declaration.
That
That's filed in which year?
That's 22, 1 year earlier.
What is the number of the?
7728 of 22.
Seeking bare injunction.
While filing the 7728 of 22, they don't seek permission and order to rule for declaration. Because if they don't seek that permission, whether the subsequent suit will lie is another issue that will arise, have to be decided. But nevertheless, my lord, they filed this suit and that is referred to at page number 22 in the trial court order, not in the appeal papers, paragraph 3 of the order of the trial court.
Yes.
The plaintiff contended the defendant, who is an utter stranger to the said property, allegedly interfering with her possession and enjoyment. Thus, to seek protection order, she has been constrained to file OS number 7728 of 22, wherein the defendant one appeared and filed an application under Order 7/11. But when the plaintiff had sought an interim injunction, court dismissed both the applications. So they are aware and they come to court and they withdraw the case and they don't seek leave under Order 2, Rule 2. What is the effect of that on this current suit is something which will fall for consideration. Now, my lord, the trial court, my lord, has examined every aspect of the case. My submission is, my lord, kindly turn to page 34. That's the question formulated, para 10.
Yes.
Whether plaintiff makes out a prima facie case. Then, my lord, page 38. para 16, court is examining plaintiff's case. That's what needs to be done. And court comes to the conclusion, prima facie, their title is subject to suspicion. It cannot be believed, and it looks like it is not a fair one, it's fraudulent. That's the finding that is arrived at. In the above para 16, the above background, if factual matrix of plaintiff is considered, her case is that one Fayaz Khan, being the owner of land number 242/1, measuring 2 acres 29 guntas, allegedly sold the same in favor of Shashikant Rao and Deepak under the registered sale deed dated so and so. Thereafter, they allegedly got the land converted for residential purpose by the conversion order, out of which they allegedly sold 18 guntas of land in favor of plaintiff's husband under sale deed dated 12/8/2020, who in turn formed the layout and gifted the suit. A suit A schedule number 4 and 5, which are suit A schedule property in favor of plaintiffs on 11/11/20. Defendant number 1 has produced documents showing that Fayaz Khan executed general power attorney in favor of Krishna Bhatt, who was the president of the host society, under GPA dated so and so. Then, my lord, please go to next page. There is a reference, my lord, to the sale deed of 13/2/2003, based on which she had allegedly told the got the kata from jurisdictional Gram Panchayat, later on from Town Municipal Corporation, sold the said site in favor of defendant one herein under sale deed dated 13/2/2003, who put up the sheds and placed his tenants in the said property, erected a compound wall. Then some police action, etc. I'll not trouble your lordships, my lord. Then there is a reference to this suit, my lord, just now which your ladyship saw, my lord, the judgment
22, yes, I've seen that.
2236.
Yes.
Then bottom, my lord, of that the court is examining last 2 lines of page 41. Finally, the court was pleased to hold that it is defendant number 1 who is in possession and enjoyment. If that aspect is correct, this court is the opinion that the plaintiff's vendor themselves have not proved their possession over land in survey number 242. The question of purchasing vacant land, selling 18 guntas in favor of husband, who in turn forming a layout and gifting the said property in favor of plaintiff, highly doubtful for the following reasons. Then our court examines what are the factors which go to show that they were not in possession. My lord, RFA, he refers to the pending appeal.
I've seen.
Then, my lord, Vishwa House Building Society, your lordship just now perused that. The action against government. Then, my lord, my learned friend referred to the order of the Honorable High Court. Then SLP. Thereafter, my lord, they didn't comply. Complaint is given. And finally, kata is issued. And I have taken all steps, got all approvals. At page 48, para 21, the court, my lord, prima facie comes to this conclusion. What is the prima facie case that they have got? Para 21. If the above incidents are considered, the case of plaintiff is fully doubtful. At the cost of repetition, this court would reiterate the important sequence of events taken place as per documents placed by the defendant to show materials available, particularly placed by both societies, are considered. Firstly, it is not the case of defendant one or the both society that the society had formed the layout in a land acquired by the government for their benefit. It's their categorical contention that the original landowner, including the owner of land bearing survey number 242/1, have executed GPA in favor of the said society, based on which they found the layout, allotted the sites, executed the sale deed. So, my lord, this entire argument, based on the orders, my lord, regarding acquisition, not acquisition, all those things, has no bearing. That's what the court comes to the conclusion, because people are deriving title through a power of attorney. My lord, if it, under law, my lord, a power of attorney need not be registered. Till recently, there was an amendment that required it. Otherwise, it has been the practice, my lord, in Bangalore, in Karnataka, everywhere, that a general power of attorney need not be registered. If it is a specific power of attorney relating to a particular piece of property, empowering the agent to admit execution.
But that's what has happened by virtue of this.
No, this is a general power of attorney executed.
Given,
Yeah.
no, the court's finding is by
Yeah.
virtue of that GPA,
Yeah.
the property is given to the Vishwa Bharati Society.
No, that's what I'm pointing out. Please see para 48, my lord. What the court is noticing
No,
is,
only as far as when the property is an immobile, the rights in the immobile property have to be transferred.
Yeah.
All the documents should be registered documents.
no, my lord, the general power, that's why, my lord, the first sale deed in favor of my predecessor is 96, executed by general power
Society.
attorney holder from Fayaz. Fayaz was the owner. Fayaz gave a general power. And the power attorney executed sale deed in 96. That sale deed, somebody must challenge it.
No, no, no. The sale deed is executed by the society.
Society, not as
Not by
power of
Fayaz.
attorney holder.
That's true, my lord. Fayaz,
For understanding the facts.
Yeah.
No, the fact remains is from the Fayaz has executed a GPA in favor of the society.
yeah,
Now the society in turn has sold it to Jayanti. Jayanti has sold it to D1.
my lord, if I am the owner of a property, my lord, and I give a power of attorney to society, as society, I give power of attorney. Society executes sale deed. I am the owner. It is an agent. It will execute sale deed as my representative. My lord, in the earlier days, my lord, when these house building societies were working, land aggregators were there. My lord. Suppose they want some 200 acres of land to make a layout. They will identify a land aggregator. The land aggregator, my lord, will discuss and negotiate with various
No,
landowners.
is it your submission that basing on the said GPA, Vishabharti Trust has got the right to
Yes,
transfer the property in favor of third parties?
yes, that's the case. And nobody has questioned it till now.
No, that's a different aspect. We are on the legal aspect.
Yes, legally,
That
my lord.
according to you, as per you,
Yeah.
it is permissible that without basing on an unregistered GPA,
Yes,
the Vishwabharati has got a right to the, to
As
transfer
agent.
the property in favor of a third party.
as agent, my lord. Vishwabharati is acting as an agent. Therefore, there is no difficulty there. But one important aspect is this, my lord. Please see at what juncture this is raised, who raises it,
That is,
and
that
how it is raised.
That is a second, other aspect which we have to consider.
Please.
Now, step one,
Yeah.
as far as that submission, that finding of the trial
Yeah.
court, what it is. Now, if this finding of the court is right, then they're entitled for injunction is not the issue.
No, my lord, I'm not even saying that. I don't admit that even if this finding, my lord, has to be reappreciated, it can't be done at this motion stage. It has to, my lord, await for the trial. The document has to come. People who have to execute it have to come. Why is it, my lord, he is seeking a declaration of title, my lord. There's also what is known as a law of limitation for all this. 1996 document. Can you challenge it whenever you want to say that the document is illegal? Why? Because in some proceeding, in some matter, the High Court, Honorable High Court has taken a view that litigation was that this land must be acquired. And the court comes to the conclusion, we can't issue such a mandamus that you must acquire the land. But if aliened outside of this, if the society has paid money to Fayaz and it has taken a power of attorney and it has executed, it has made the layout, it was a common pattern, my lord, that was done because if large extent of land is there, on a power of attorney, they would finish the layout, then invite applications from the members and allot sites to them.
PA gives the power to the power, to him to transfer the right and title in the property where there is a clause of alienation, then it has to be a registered
No, my lord,
document.
with due respect, I submit, but I'll place authorities for that.
Yes, please place
Yes.
that.
There is no requirement in law that a general power of attorney which authorizes the agent to sell the property of the principal needs to be compulsorily registered. At that relevant time, it's not there, I'll place authority.
Who will execute, who will be signing the document?
It'll be signed by the agent. The power of attorney, original, Fayaz is the owner. He executes a power of attorney. It is signed by him. The agent will execute the sale deed to say, I'm executing this.
So now the giving, a person who has no registered document basing on a strength of a GPA.
Yes.
He will transfer the right and title in
Yes,
respect of
of
an
the-
immovable property.
Yes.
And that agreement, he would be executing the document in favor of that third
Yes,
party.
as agent. Now, I'll give another example, Manoj. Suppose there is a company. The company authorizes a managing director to do so many acts.
That is a different aspect.
No, I'm just giving this as an analogy, Manoj. When
We are referring to a immovable property.
immovable property only, my lord. We'll take immovable property. The company owns, my lord, a property, my lord, in Bangalore. The company wants to sell the property. It gives a general power authority to the director or a company secretary or somebody, please go and execute the sale deed. He goes and executes the sale deed. He doesn't say, I am the owner, I'm executing it. He'll say, I am the agent, my company is the owner, I'm executing it.
Before the registering authorities.
Yeah.
Just to present a document
Yes.
before the registering authority is altogether a different aspect.
Not presenting, he executes it. On behalf of the company, he executes the document.
Company can give them that power.
Yes, as a, my lord, very often, my lord, power of attorney is given to either a trustee or one of the office bearers or a company secretary or a chief executive officer to go and execute documents. So he or she can go and execute the document. He is not executing it in his name. Society here is not executing it in society's name. Society is executing it as agent of the owner of the property, and that is perfectly permissible. My lord, I'll place authority for that. No difficulty with that. So how does the
Lords,
court deal?
just on this point, Lords, if the sale deed itself is seen, my Lords, the society claims I am the absolute owner. It is not acting as if it is the agent. If this 1/6/1996 before, my Lords, if the sale deed is seen at page 89, the society is acting as if it is the absolute owner, not as an agent. It has not signed this document as an agent also. Page 89 of the documents which I have given. Page 89.
Yes.
Society says, I am the absolute, you're at page 90. Vendor society is the absolute owner in possession. It's not saying I am the agent of the landowners of so and so based on a GPA. GPA doesn't even find place in this entire sale deed. Wherever he is acting as a GPA holder, my lord, it has to say so and so is the vendor by GPA holder, so and so, then the sale deed can be executed. Not society claims I am the absolute owner on the basis of GPA. That is an unregistered document.
The senior content.
Please.
My lord,
Sorry.
I was reading at page 48 bottom.
Yes.
How the court has dealt with it. It is a about 5-6 lines on the bottom.
Yes.
It is their categorical contention is that the original landowner, including the owner of land bearing number 242/1, have executed GPA in favor of society, based on which they formed the layout, allotted the sites, executed the sale deed. In their layout, around in the land measuring 60 acres, 900 sites have been carved out between 86 and 2004. They all sold 700 to 780 sites by executing registered sale deeds in favor of members. Secondly, the said layout has been developed fully with all urban facilities consisting of road, sanitary, drainage, water, etc. Endorsed by commissioner by letter dated so and so. KEB in its letters approved to provide electricity and layout to the society, which includes street lights. Letter dated 28/2 issued by BESCOM along with list showing starting from 1999 itself, allottees to the site have put up the construction, got the electricity connection. Further, there is a list of 13/1/2011 supplied by sub-registrar under RTI stating that between 89 and 2004, the above said society has executed 778 sale deeds of sites carved out in so-and-so village in favor of its members. The said layout initially under the limits of Pattanagere Gram Panchayat, later in Pattanagere Town Municipal Corporations issued khata in favor of purchaser. Divisional Commissioner has passed an order not to mutate khata in favor of so-and-so in the site named, against which suit was filed, seeking mandatory injunction, etc. Thereafter, my lord, suit was decreed, mandatory injunction was given. Then khata was given, there was some other proceeding related. Kindly now go to page 53. My lord.
Yes.
There the court is referring to this suit of 2236.
Yes.
Your ladyship's already read it, my lord, last 4 lines.
Yes.
Suit for injunction decreed. That is to say, in the year 2013 itself, defendant one was in possession
Yes.
and demolished the purported interference. Then, my lord, page 55.
Yes.
Para 26. Now, the court is examining plaintiff's case. What is their case? Let us see what their case is. When the vendor of the plaintiffs themselves were not in possession of suit B scheduled property, then question of they selling land in survey number 241 measuring 18 guntas in favor of husband of plaintiff and he forming the layout, gifting suit sites number 4 and 5 in each stage of immunization cannot be believed. So how could he sell it? He was not in possession, is not having a title. And they had not agitated the sale in 1996. I can understand, my lord, if there was a suit filed in 1996, between 96 and the time that they purchased the property in 2011, to say that the sale deed, which is registered document, is illegal one, therefore declare it as to be illegal and permit us to purchase this property. Or after they purchased it in 2011, they could have done it. Then also they don't do.
That was never the contention before the court, nor it was decided with regard to limitation.
No, limitation is a point, my lord, which the court is bound to take note of, even if not raised.
No, not raised in this.
Yes, I agree it's not raised, but I am submitting respectfully recent Supreme Court says that even if the defendant does not raise a question in the suit, it is the duty of the court to examine limitation. And I submit, my lord, this delay is a facet of discretion to be exercised. Now, my lord, here is a case where a person comes to court after so many years and he raises all these issues of title. He could have raised it earlier, he doesn't. He suffers an order against himself. That order is not stayed. Maybe he says, I had some problem, whatever problem he had. But that order is not interfered with till today. It is there. Now, an order which is passed inter partes is binding. No court in collateral proceeding, my lord, can say, we will keep it aside, we'll ignore it, we'll do something else. That can't be done. They are bound by it. And when they are bound by it, they can't argue to the contrary. They can't now say, I had problem with my lawyer, therefore I didn't appear. All that is a matter story, my lord, which some other court will have to hear. Today, my lord, that order is there. No, and that order says, your declaration is given to me, I am the owner. An injunction.
The bare injunctions.
My lord, while doing that, the court is recognizing my title. That's what I'm saying. I'm not saying it's a declaration suit. The court is recognizing, because court examined title.
Incidentally.
It examined title, it examined possession, both. I can understand a person claiming, not saying, I'm not the owner, but I've been sitting here for so many years to protect my interest. That's not the case. And my case was, I'm the owner. I produce the documents and I say I'm entitled to remain in possession. That is granted. So, my lord, can that be ignored is a question. The court, my lord, examines that at page 55, my lord.
Yes.
The court is now examining again the plaintiff. Para 27.
Yes.
Shashikant Rao and Deepak, after purchasing land measuring so and so, they applied for conversion with the land with Deputy Commissioner, for its report was sought from BDA. After conducting spot investigation, filed a report dated so and so stating there is no vacant land for conversion. The land on which conversion is sought has already been fully developed with civic amenities, and also reported in the said land there are construction of buildings. Also reported the survey sketch prepared by the surveyor, there is some variance on actual status. Despite the said report, Deputy Commissioner went ahead passing an order by passing conversion order, which appears to be without examining ground realities of land. Thus, no much reliance can be placed on the conversion order, as prior to the year 2020, number of litigations have been held on layout formed by Vishwabharati, in which there were continuation findings stating that there is a fully developed layout in a land measuring 60 acres, sold more than 780 sites. If these aspects are considered, purchase of Shashikant Rao and Deepak in respect of 242/1, measuring 2 acres, 11 guntas, claiming as agricultural land, getting conversion and sale of 18 guntas in favor of plaintiff's husband, who claims to have developed the layout and gifted the suit, a scheduled property in favor of plaintiff, appears to be clearly misuse of machinery. It's a clear case of creating overlapping transaction to exploit allottees by taking ground. The development of layout by society was not based on acquisition. This is also considered by the court. Then one last thing which I would like to read is this. Court wants to sum up the observations made supra based on document produced by both sides. Series of transactions have been held in respect sites formed in so and so, would clearly unequivocally show landlords have executed general power attorney in favor of society, who developed layout by obtaining layout from the Gram Panchayat. Lord, I'll skip some portions, Lord. Last 4 lines. The defendant one has made out prima facie case is the vendor. By obtaining sale deed in possession, he was in possession of the same, putting up shed, purchasers tried to interfere, he filed a suit, court has granted a decree. Therefore, my lord, he has no semblance of right. Then, my lord, next page, page 60, there's one more, my lord, interesting thing that the court notices at paragraph 29. The case of the plaintiff is full of doubt, wherein the material placed by defendants are clinching on the title and continuous possession. That apart, there's a decree in favor of defendant, that too against vendor, which is much prior to sale transaction. Plaintiff, his sale deed is dated 12/8/2020. Thus, plaintiff made no prima facie case. Then, my lord, construction, next page, my lord, he notices that construction has been completed, and that IA number 11, not by mistake, it is shown as IA2, it should be IA11. Then he gives them, my lord, one more reasoning at page 62. The case of the plaintiff appears to be arm twisting against persons who is having possession based on title since 13, it should be 2, my lord, not 3, 13 to 2003, which is on undisputed point of time, as by that time, neither the plaintiff nor her vendors were in possession at all. These people came, my lord, a good 10 years thereafter, 2011 only. More than anything else, even assuming a fact that land bearing so-and-so has been sold by Fayaz, but on the date of sale in favor of Srikant Rao so-and-so, there was no vacant land. By way of sale, there was a change on the suit, charge on the suit property that apart no material to show identification of suit property. Then, my lord, the only last submission I would make is this, my lord, that in a matter like this, my lord, it is very easy for the plaintiff to come to court at their own leisure. Building is completely built. There is a developer, my lord, who is respondent number 3 before your
What is the
lordship.
nature of the land?
Pardon, my lord?
What is the nature of the, I mean, what is the
Apartment,
construction that is
residential
made?
apartment, my lord. It's a 60 by 40 plot, which has, my lord, 4 floors. Each floor has got 2 apartments. My client, the owner, the second defendant, has equal
When was the
number.
construction completed?
Construction is completed, my lord, nearly a year ago. No, it's just lying like that. The builder has put his money and he has put up the construction. Now, my lord, if they say,
No, and in the year in Jan 2023, there was a joint development agreement. Subsequent to the joint development agreement, he might have started construction.
yes,
In the month of Jan 2023.
yeah, building is ready.
So to construct a building, it takes at least.
No, building is ready, my lord. I have photographs of the building. They admit it. Building is ready. It's ready for occupation.
But definitely after filing of the suit, my lord. It's
Hmm?
not as if they had constructed the, after filing of the suit only the construction.
They also admit.
Because it is there, my lords, as your lordship pointed out, joint development agreement itself is. After the JDA, they have started putting up construction. That is the reason, my lords, why we withdrew the earlier injunction suit. Your lordship may kindly see, filing of this suit it is not as if they caught off guard, my lords. They were on caveat, my lords. They were on caveat. We served the caveator. Your lordship may kindly take the order sheet. We served the caveator on 24/1/2023. This person takes the caveat in this suit. And instead of taking the service of a lawyer, he is a retired professor. It is not like he is an ordinary. He was on caveat. He was saying, and for his advocate, we served the copy. Still, my lords, they see that this person himself comes to the court without the assistance of an advocate and gives an undertaking, I will not create third party interest. Look at their conduct, my lords. They were on caveat. It's not as if they were caught off guard. And earlier, my lords, had filed the suit for bare injunction. Since I had no benefit of TI, they started putting up construction. That is the reason we had to file a fresh suit and withdraw the earlier suit.
Yes.
And one more thing, my lords. Your lordship may kindly take my sale deed, that is my husband's sale deed, my lords, which is 12/8/2020 from M.R. Deepak and Shashikanta Rao, that is page 36 to 57. My lords, it is for a valuable consideration. If at all, my lords, I had the intention of only disputing, harassing or making money, I would not have purchased this property of 18 guntas for a consideration of 1,79,74,000. And this consideration has flown through check. But therefore, my lords, I have come to this court with a prima facie case. And I am not, it is not as if I have suppressed the filing of earlier suit. I have disclosed that also while filing this suit. And my lords, look at their conduct. They were on caveat. We serve on their advocate. Instead of their advocate, this very defendant appears before the court. He says, I will not create any third party. He has already gifted the property.
Heard reserved poses matter on the Thursday for pronouncement of judgment.
Lords, now please see explanation 1 to section 3 of the TP Act that indicates that once a registered document is there, it is notice.
Yeah, that is construction.
And for a moment, my lord, at this point of time, we are not by any means conceding that there is a GPA. We are disputing the existence of GPA also. Because it's an unregistered GPA. We do not, at this point of time, admit the existence. But we are only saying, even if this GPA is there, there is no proper conveyance on the basis of this GPA.
Yes, Thursday.
But till then, my lords, not to alienate. Because this benefit was there throughout, my lords. And the trial court also
Matter on Thursday till such time, not to alienate.
Grateful, my lords.
12 and 13, adjourn 14. Jai Prakash B.
Reserve. On pronouncement, give a date of. No representation. For the petitioner, it's a RPSC of 2016. Pose this matter for dismissal on 17th September. Yes, 15.
15. Sandeep Lahiri. Serial number
Going for
15.
respondent, my lordship. Kindly have it and.
Where is the petitioner? Yes, Mr. Sandeep
Sandeep
Lahiri.
Lahiri. Serial number 15, Sandeep Lahiri.
The request to plan counsel for the respondent. When do you want?
1 week, my lordship.
On 23rd. Yes.
16 adjourned, 17, Nanjunda Gowda.
Trial court filed by the
Huh?
wife filed by the 120 proceedings, my lord. Maintenance of 5,000 as wife and child is 5,000, my lord. I challenge before the court, my lord, RPF similar. She is also working, my lord. Employee in
How much
petition,
is granted? 10,000.
10,000, my lord.
What is your income?
Coolie work. Auto driver, my lord.
What is the finding of the court?
Trial court. She petitioner is working in the auto driver.
When was the application filed for maintenance?
Maintenance is 5,000, my lord, trial court.
When was the application filed for maintenance? What is the date of application?
Date of order, my lord. Date of petition.
Application, petition, whatever you call it. Any, sir? Date.
Petition.
It's on 8/4/2022.
Oh, please.
Please come. Land Council Breach submits that the petition is a daily wage worker. In fact, the wife is working and earning. The trial court, without considering all this, has directed the husband to pay an amount of rupees 5,000 to the wife and 5,000 to the child. And he has no, is not in a position to pay the said amount. Considering the same, there shall be stay of all further proceeding pursuant to so and so, so and so, on the condition that the petition shall continue to pay an amount of rupees 5,000 by 5th of every succeeding month.
Please.
The petition is filed on 8/4/2022. Towards at 5,000 by 5th of every succeeding month, and at 5,000 arrears of an amount of rupees 1,40,000 shall be deposited within a period of 8 weeks from the date of receipt of the copy of the order, same default order. And the
As
petition.
per order, my lord, I will comply comply the order, my lord. As per 5,000 already deposited trial court, my lord. Already, no amount is arrears is no balance, my lord.
You are depositing 5,000.
5,000 already trial court has already maintained paid the amount, my lord, respondents. Already.
From when you are paying?
My lord, trial court is interim order. Trial court interim order is granted, my lord, 3,000 per month. Already granted is 3,000 per month is already paid, my lord. Interim order.
You have been paying? how
Paying,
much? 3,000.
3,000 already
So
paid.
now the court is saying 5,000.
5,000.
So 28 into 56,000.
Please.
It is submitted that he has been paying 3,000 during the pendency of the petition. As hence the arrears as of now are calculated at 5,000. So remaining 2,000 plus 28 for 28 months comes to 56,000, 8 weeks. Same, but the notice to the respondents on the default order was this matter on 30th of September.
Please.
Yes.
18.
On such deposit, the wife is at liberty to withdraw. Yes,
Appear for petitioner, senior not well, kindly have it on Monday, my lord.
yes, Monday, not Monday, post it on Thursday. Yes,
B group matters, serial number 19, Victor Manoharan.
no representation. Post on 21st of October.
20.
Petitioner. The respondent. The only section 24 application came to be allowed, my lords. The short point which arises for consideration is the order. I'm only restricting my prayer that order should have been passed from the date of application. Instead, it has passed from the date of petition. That is what my ground is, my lords. That is
Meager
what law
amount has been
contemplates.
ordered by the trial court, my lord. Only 4,000 has been ordered.
Whatever is the order, let it be from the date of petition. When you
Since,
have
my lord,
asked for.
the
why it should
petition
be
is
from the
filed
date
in the
of,
7 years back. My daughter was at 7 years old. Now she has she's going to, she's
What
studying
he
in
says
second year
is, what he
PUC.
submits is correct. When you have filed, you wanted maintenance at some point of time, you filed an application. So from that day, you are entitled. Why from the date of filing of the divorce petition?
On the other hand, I have filed the conjugal rights also, my lord. Only thing is we have no source of
On the
income for.
IA, we will, as far as that is concerned, we'll modify the order. Let it be from the date of your application. for
Application is dated
maintenance, not from the date of your petition for restitution.
ink page 46. Your lordship will get the date of the application. 17 to
No, that's what
28.
we are on the concept, we are regularly, that's the order that is passed. Why there is an exception in this case? That is from 17 to 2018, you are entitled.
Yes, ma'am.
Court has granted from 2015.
2016 from the date of my MC petition, ma'am.
Where is the, where
2015.
is the order impugned?
Well, the impugned order, your lordship will find it. Ink page 59, please. ma'am.
59.
Ink page 59, 59, please. The interim application filed by respondent is partly allowed. She is granted an interim maintenance.
Agreed with orders passed in IA dated 17 to 2018, whereby the trial court had granted interim maintenance of an amount of rupees 4,000 per month from the date of the MC, that is in the year 2018. The husband is before this court. Learned counsel for the petitioner submits that he has no difficulty to pay an amount of rupees 4,000 to the wife. He submits that when the application itself is filed on 17, application under section 24 of the Hindu Marriage Act is filed on 17 to 2018. The court was not right in granting maintenance from the date of petition, that is in the year 2015.
11/8/15 minutes.
11?
11/8/2015.
11/8/2015. Then council submits that he's only aggrieved to that limited extent. Next para. Then council appearing for the MC is filed by you.
MC is filed by me for seeking divorce, my lord.
It is
Prior
submitted-
to that,
Land counsel for the respondent submits that the husband had filed MC seeking divorce and the wife had filed a petition seeking restitution of
conjugal rights.
He submits that when the parties are staying separately and the wife, husband had a responsibility to maintain the wife, and when he failed to, wife and the only no children. Have
We have, I have a
responsibility.
child, my lord. I have a female daughter. Got a female daughter. Now
All the
she's in
expenses,
second year PUC.
my
my lord.
instruction is all the expenses in the kid is borne by husband only.
When he has a responsibility to take care of the wife, the court had rightly granted the maintenance from the date of filing of the petition. MC 42 is a divorce petition.
Divorce petition. ma'am.
Granted it from the date of the petition, that is, in the year 2015. And he submits that even the maintenance that is granted is a meager amount of 4,000. And the order seeks no interference from this court. Next, having heard the counsels on either side, there is the material non-record. MC number 42 of 2015 is filed by the husband seeking
No, no,
divorce.
40 is filed by wife.
42 I said.
42 is by husband, man.
That's what I
Please,
said.
man, sorry.
MC number 42 of 2015 is filed with the husband seeking divorce in that. The wife had filed an application seeking maintenance on 17/2/2018. In all the cases, the maintenance is ordered from the date of the application under section 24 of the Hindu Marriage Act. Whereas in this case, the court had ordered maintenance from the date of petition. This court finds that there is force in the argument of the
submission, my lord.
counsel for the petitioner.
Since
Accordingly, the order of the court granting maintenance at 4,000 from the date of petition is modified. And the husband is, husband has to pay the maintenance of an amount of rupees 4,000 from the date of, from 17/2/2018. Accordingly, a
one
petition is
submission, my
put-
lord. Till the submission of filing of my interim application seeking my maintenance, my father was working as a government servant. He used to take care of my child and even my.
That's why you have got it from the petition. You've got it from that petition. No, that's how it is. There can't be any exception in your case. That's how the courts are passing orders. Yes.
And my liberty may
Disposed
be
of.
granted to file the
Huh?
enhancement petition.
Ah.
Liberty may be granted.
Not required. You can anytime. Court did not give you liberty. Next.
21,
Much obliged.
Marigoda.
No representation for both the parties. Both will be matter on October 22nd.
22, Anis Ali Khan. My lord, offering for respondent side, it's praise time. Senior has got fracture. She's unable to work, my lord.
This petitioner, no representation on behalf of the petitioner. Counsel for the respondent seeks time. Pose this matter on 16th of October. Yes, 23.
3,
Appearing for the respondent, my lord.
Huh?
Appearing for the respondent. The main case of MC 459/16, it has already been allowed,
Disposed of.
disposed of in the trial court, my lord.
It appears that
By
disposal.
both the counsel that the main MC itself is disposed of. You have the date,
16/7/2019.
16/7/2019, in that view of the
Well,
matter.
a date may not be correct, it may be counterchecked.
Not, that is disposed of.
Yes.
In that view of the matter, no further orders needs to be passed on this petition. Accordingly, the same is closed.
Please, my lord.
Yes, next.
hearing on Iyer. Serial number 24,
I appear for the appellant, your lordship. The present appeal is filed under section 64, under 54, clause 1 of the Land Acquisition Act, 1894. That is the old act, your lordship. Here, what has happened is, the appellant is the National Highways Authority of India. Now, what has happened is this appellant before this honorable court was not a party to the impugned judgment, which is at Annexure A, your lordship. What had happened is initially the preliminary notification is of the year 1993. When the acquisition was initiated, this particular stretch, your lordship, which is the subject matter of the present proceeding.
Please tell the court. When was the award passed?
The award was passed by the Special Land Acquisition Officer, that is respondent number 3 in the instant case in June 1995. I'll give the date.
Now, again, is that order you will appeal now?
As against, under 30th June 1995, 170 rupees per square meter was fixed for
That's
the
what I'm
acquired
saying.
lands.
You are questioning an award that is passed.
No, I'm not, I'm happy with the award.
Then
Award as against this 170 rupees per square meter, reference petition was filed before the reference court. That is the City Civil Court. The City Civil Court has enhanced the compensation by the impugned judgment.
was
That is 31st May 2022. Compensation was enhanced at the rate of 38 times from 170 rupees per square meter to 6,445
who
rupees
has
per square
contested that
meter.
matter?
Please,
Who
sir.
has contested? Who are the respondents? Land acquisition officer.
Land acquisition officer, state land acquisition officer. Subsequently, in
Who is the
1999,
beneficiary?
National Highways Authority of India. May I pass on the notification by which the central government entrusted this particular stretch of lands?
Then you have to,
National
then why were
Highways
you not
Authority
pursuing
of
the
India.
matter? You know what has happened, what is the award?
Unfortunately, your lordship, what had happened is there were as many as 45 cases which were filed
Finish
before
to
the-
notice.
Your
I-
lordship, may I just make one submission, your lordship? Execution when landowners filed execution proceedings, that is when we got the knowledge of the
Court
proceedings.
is not a case for stay.
My lord, all other 42 cases have already been
They
stayed
are
by
not
this.
where where you sought for this IA for, in all those cases, you're party.
We were a party. In these three cases, we were not a party.
We will see.
So we
We
had
will
no
see.
knowledge, your lordship, only when execution proceedings
Let
were
the other
filed.
side come, we will see.
Your lordship, may I request just for next week, because 11th, they're pressing on.
Taken on, it has to be served on them.
They are very much aware. In execution, each date they are pressing on
Then
warrant.
serve the notice on them and come back.
Please, your lordship, may I request for next week
Petition is
itself, your
permitted to,
lordship.
appellant is permitted to take out, take hand summons on the counsels appearing for the respondent for the executing court and file a memo to that effect. Pose this matter on 12th of September.
Your lordship, 11th is the execution.
10th of September.
Please, highly obliged.
Yes,
25,
10th of September.
please, obliged.
Yes.
The delay of 34 days in filing the appeal, my lord.
Notice.
And respondent is nil. Respondent is nil. Nil.
What is this?
Is a probate, it was dismissed.
Give that.
There is no delay, it was dismissed on the ground that there was a delay in filing the petition for the probate.
Find this petition for petition of probate of the will dated 16/6/1965.
Oh,
Yes, a delay of IA number 1/24 is filed to condone the delay of 58 days. The reason stated, the delay is condoned, post appeal for admission on 13th September,
sorry, date, man,
13th September.
30.
26, Yogashri.
Listen in this case, my lord. Some matter may be taken up by 2:30, please, my lord.
Yes, next.
27,
Petitioner.
Rupesh Kumar.
This case, we challenge the order passed by the trial court in semis number 305 of 2019, man. It was an ex parte order, man. The petitioner, my lord, was not in station, my lord, during the pendency of this proceedings, my lord. And no summons was served on him, my lord, although the order sheet.
When was the order passed?
The order was passed on first day of August 2019, ma'am.
1st August 2019.
Yes, ma'am.
When did you come to know?
2022, ma'am.
Huh?
2022, I visited India.
Where are you staying?
I was in Kuwait, ma'am.
You never came in between?
Since there was COVID restrictions, my lord, I was unable to come.
Notice.
Lord, there
Notice
is
the
warrant issued as against the petitioner.
Certainly, that's how you will come. Otherwise, no reason. What was the amount granted?
10,000, total 15,000, ma'am.
15,000.
Yes.
When was the petition?
I'm during
What's your income?
income now. I have left my job, my lord. In
No,
Dubai.
you were working
At that time,
earlier.
30,000.
30,000 in Kuwait. What do you do?
No. He was a plumber, man. That's plumbing workers.
Plumber will get 30,000 in India also.
But he was getting only so much, man.
What was maintenance? 15,000.
15,000.
Children are there?
Sorry, man. Only one child.
One child.
One child.
So you have not been taking care of the child also all through?
My lord, between there is 498A proceedings, my lord, which is also pending. The respondent herein was also living with the petitioner, my lord, until April, my lord, this April 2024.
When was that application filed for maintenance?
2019, man.
Which date? You are talking about the order.
Yes.
Order and application are both of 2019.
Yes, it was an ex parte order, my lord.
What is the amount? What is the date of petition?
Date of petition
Application
is
for maintenance.
16/4/2019, my lord.
16/4/2019.
Yes. Date of order was first day of August 2019.
So 64 months, sir,
Yes.
as of now.
No, in between, my lord, the respondent was residing with the petitioner, my lord. And after during April, my lord, she left the company of the petitioner, my lord, again. And now she has filed the execution petition.
How much you're going to deposit? On that only stay will be granted. You have to continue, you should continue to pay some amount and also on deposit of some amount towards arrears.
50% I'll deposit. ma'am. And the 50% of
50% of what? Of 15,000?
15,000. Every month I'll start paying, my lord, from,
So 7,500 into 64 months.
my lord, that will be exorbitant. Ma'am.
That's why I asked you.
I'll deposit
Continue to pay 7,500. How much amount you will deposit?
1 lakh. Ma'am, I'll deposit.
Yeah. Deposit 1.5 lakh. Land counsel for the petition, IA number 1 of 24 is filed to condone the delay of 1029 days in filing the petition. It is submitted that when the proceedings were initiated, he was in Kuwait and recently came back to India. As such, he was not aware of the pending proceedings. No summons were served on him. Issue notice on IA number 1 of 24. Next. Land counsel submit IA number 2 of 24. Land counsel submits that now the execution petition is filed. Filed unless the stay is granted, the petition would be put to hardship. It is submitted that he's working as a plumber earlier and earning 30,000. Now he has come back to India. There is no, he is not having any, he's not working here. Considering the submission of the land council, there shall be stay of all further proceeding pursuant to so and so, on the condition that the petitioner shall continue to pay 7,500 every month, 7,500 by 5th of every succeeding month, and shall pay an amount of rupees 1,50,000 within 4 weeks from the date of receipt of the copy of the order, same default order, either of it. Yes, post this on such deposit, the respondent is entitled to withdraw the same. Post this matter on October 14th. Yes, next.
Final hearing matter, serial number 41. Shant Kumar Kesi.
You appear for the respondent.
Please.
There is a counsel, Shanta Kumar. You are ready?
My lord, morning is taken, I sought for adjournment.
Morning.
Morning is.
Why it was not granted? Nobody has sought adjournment.
Appellant,
No.
he told me he message.
2014 matter, both of you are not. In the afternoon, we'll hear this matter. Ask him to come.
Please.
Second 42 also in the afternoon.
43. Ajesh Kumar.
All 14 matters. Let all of them pass over. We'll see that.
Appearing for the appellant, my lord. So, my lord, this is a suit for partition
So for
and
the respondent,
for the appellant, my lord.
ready?
My lord, we are kindly seeking some time. We will,
But court is not kindly and kind enough to grant. So please come in the afternoon and argue.
my
Yes,
lord,
next.
my senior is not in town, my lord. He's in Delhi attending to matter.
You argue the matter.
My lord, kindly
2014
please.
matters will not, no,
My
appeal
lord,
of 2014 is pending. So what will happen to the, yes,
my lord, please, I bow down before this court. Please allow it at least on Monday, my lord. Would that,
post this matter on Wednesday at the request of land counsel for the appellant. Yes, 44.
44.
Yes.
Seeking for a short accommodation, Mulats. Only call next week. Any date we're fine, Mulats.
On cause.
The difficulties, Mulats, my senior is traveling to Chennai today, Mulats.
Why should he travel to Chennai when there is a working day?
No, Mulats. He has a briefing there in the NCLAT.
Still, when what will happen to this case?
One opportunity may be granted, Mulats. If we're ready in the matters.
Matter at the request of land counsel for the appellant. Post this matter on 18.
I'm grateful, Mulats.
This is also done. Mhm. Not 4:30, 2:30, I think. Oh, I think why don't you, say that this list also will take it up at 4:30. Make some, display so that we'll complete it. I don't think because less matters are there. Just display that it will be called at 4:30. But it will be called at 3:30 and
Court officer, madam.
2:30ಗೆ ಕರ್ಕೊಡ್ತೀನಿ. ನಾವೀಗ ಹಾಕ್ಬಿಡ್ತೀವಿ ಡಿಸ್ಪ್ಲೇಗೆ ಯಾರ್ಯಾರು ಬರ್ತೀರಾ?
ಹೌದಾ 2:30ಗೆ ಕರೀತೀರಾ?
2:30ಗೆ ಕರಿ.
Okay.
2:30 ಮಾಡ್ರು 4:30 ಮಾಡ್ರು ಎಲ್ಲ 2:30ಗೆ ಕರಿ. List number 3, 4:30. List number 3 will be called at 2:30 ಅಂತಾನೆ ಹಾಕ್ಬಿಡಿ.
Hello,
Will be
hello.
called out at 30 ಅಂತ.
Hello.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಇದು 2:30ಗೆ ಲಿಸ್ಟ್ ಇದೆಯಲ್ಲ
2:30
serial number
ಕರೀತೀವಿ.
2:30ಗೆ ಕರೀತೀರಾ? Okay.
ಅಲ್ಲಿ ನಿಮಿಷ. 2 days ಇಲ್ಲ ಎಲ್ಲದಕ್ಕೂ ಏನು ಕೊಡಲ್ಲ. Memo should be filed post on 10 ಅಷ್ಟೇ. 44/18/9. ಸ್ಕಿಪ್ ಏನಾಗಿಲ್ಲ ಸರ್ ಎಲ್ಲ ಕರ್ತಿದ್ವಿ.
Hello.
11 ಆದ್ಮೇಲೆ 12:13 ಎಲ್ಲ ಅರ್ಜುನ್ ಆಗಿದೆ. 14 ಇಂದ ಕರ್ದಿದೀವಿ. 15-23 ನೀನು ಸಂದೀಪ್ ಲಹರಿ ಅಂತ ಅಷ್ಟು ಸರಿ ಕರ್ದಿದ್ದೀನಿ ಕೇಳಿ. ಮೇಡಮ್ ಕರ್ದಿದ್ದೀನಿ. 3 ಸಲ ಕರ್ದಿದೀವಿ. ಇಲ್ಲಿ ಇದೀರಾ ನಮ್ಗೇನು ನಾವ್ ಇಲ್ಲೇ ಕೇಳ್ತಾ ಇದೀವಿ. ನಾನು ಮೇಡಮ್ ಹೇಳ್ದೆ ಮೇಡಮ್ ಅವ್ರು ಇದಾರೆ ಆನ್ಲೈನ್ ಅಷ್ಟೇ. 23/9. ರಿಸರ್ವ್ ಮಾಡ್ರಿ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
suit scheduled property in OS number 78/2000 was not brought to the knowledge of this court at that time, at the time of granting an order of status quo. In other words, the said judgment and decree directing the defendant therein to deliver the vacant possession was suppressed by the plaintiff herein. My lord, my case itself is that, saying that I am having the agreement I am the agreement holder, by virtue of that they have delivered the possession. And suit is filed by them, my lord, for the injunction. Later that has been amended. Without amending the plaint also,
What is the injunction you're seeking? now?
only restraining me to not to interfere with my possession, my lord.
So that
Till
is.
disposal
No,
of this
that is
suit, my lord.
that is like, you lost a RA,
Yes.
that RA filed by you is dismissed.
Yes.
No, by filing a suit, you want the judgment and decree that has attained finality to be stayed or to be interfered in this suit. That
Yes.
is exactly is your relief which cannot be granted.
Status quo, it is because, my lord, otherwise
Can't be, that
possession will
can't
be
be.
delivered, my lord.
No,
on
it has to be.
Monday.
It has to be delivered because now you have not preferred any further appeal. Once the EP is filed, that should follow.
EP, my lord, the reason is that, my lord, the declaration, because even they are also not having any title over that, because that was finding is given. Neither the plaintiff is the owner nor the defendants are the, because there was a lease alienation, non-alienation period was there,
This
my lord.
only this thing you have to tell the court. No, he is a decree holder. There is a decree in his favor, which has attained finality. No, you filed a some other seeking a declaration.
Yes.
No, unless and until your suit is declared and that is your rights are adjudicated, can there be an order, interim order in your favor?
Here already they have declared that the agreement itself is null and void, my lord.
In which
Without,
case?
in this case, that is already previous order, my lord. They have,
What
my
previous
lord,
order?
now only I have read out that particular line, my lord.
No, it is all.
Already
no,
decided.
We'll say that, so that without the court, this finding
The
shouldn't
suit
be
is
given.
for only
Let,
bare injunction, my lord. In that they have decided the title itself, saying that they are not, I am not having any title over.
But what to do, that has become final. That has become final.
This one, it cannot be determined. If there is a full-fledged trial is required,
No,
that whether
what
the
I am
agreement
saying
is.
is, if any of the findings are not correct, that will be clarified. But you can't have an interim order in this at all.
Because otherwise it is, because from 30 years, my lord, they are by receiving the consideration. If that amount
Then
in
if
the
you
year of
feel that, if you
1995
feel that,
invested
that order passed by this court in the RA is not correct, you should have taken it for further appeal.
was the
That was,
BDA.
you
BDA
kept
is-
quiet.
My lord, BDA has taken action against the respondent number, wherein, and kindly see that, my lord, how the order is passed. One is that ground
please
for rejection
understand,
of that.
when
And second one,
we
without
can't-
making the BDA is a party also. in
Can't
this.
frustrate the judgment and decree that's passed by the court, which has attained
Because
finality.
since 34 years, I am in possession of the property
That
by
is
paying
true,
the amount.
But we have to look at the legality or other.
And I have constructed the building, my lord. Now I have to vacate the premises, my lord. Without, because if that 20,000 in the year of 1985 invested elsewhere, my lord, it would have been reach
I
more
can-
than crores to get
No,
the
I
property, my
understand
lord.
that. No, if an order is passed by this court of such nature, just see, and virtually that order passed in the the judgment, this court is saying that in this case.
Because this is a suit only for.
What is the ultimate relief that is granted? To deliver possession of so and so to the plaintiffs therein.
Yes.
That has become final. Now you say, no, let the plaintiff not take over possession from me from in a different
I am
proceedings.
not seeking for the cancellation or staying of the execution petition. my lord.
That is not the relief or the decree that is granted. Decree is to take position.
Decree is to take
Deliver
mandatory
possession.
injunction. Now I'm only restraining them to
Can't
not to
be.
interfere with
Can't-
my position, my lord, till
That is what
deciding
it
this.
is. No, it can't be done. Can't be done. You want to withdraw or if unnecessarily, if I have to pass an order, I have to give all the discussion has to be made now.
Kindly pass over, I'll just.
Yes.
Yes, ma'am.
List one, orders at 2:30. Serial number 28.
Appear for appellant, my lord,
Yes.
and kindly granted 1 week time, my lord.
Appeal of 2019. Why a Monday time should be given now? If you're not interested, we'll dismiss it on that ground. Anyhow,
Fine.
what you couldn't pursue from 2019, what will happen now?
It's,
Interim order
it's
is there
a,
in this. Look at it.
no,
No interim order. By this time,
finally, my lord, finally, 1 week, my lord. We comply office objection.
I think all this time should be granted on costs. All these
Cost-
MFAs
co-
of 2019.
Yes, my lord. We paid, serial number 29, we paid cost,
28.
my lord.
A week's time is granted finally
My-
for complying with the office objections, or in the appeal stands dismissed without further reference to the court. No further exam, it's made it very clear, but that if the office or no further application, no further request for time will be granted. Yes.
29.
Yes.
If you're for appellant, my lord. We have paid 2,000 cost, my lord.
You're paid?
Paid, my lord.
Have you filed the memo to that effect?
Today filed, ma'am. My lord, today.
Post this matter on Tuesday. By the time the council shall file the acknowledgement memo to that effect, that the costs are paid. Yes, next.
30.
If you're for appellant, my lord. Same, my lord. Week's time, my lord, finally.
We'll dismiss this up, will give that. You just can't take court orders for granted. Matter is listed for non-compliance of office objections for 4th time. Learned councillor appellant seeks for further time. Since sufficient time is already been granted, further time cannot be granted only on cost. Hence, a
Kindly
week's time is
granted 2
granted.
days time, my lord.
Comply with office objections.
Kindly granted
A further
2
time
weeks.
of a week's time is granted on cost of 10,000 to be paid to the Legal Services Authority.
2,000, my lord. 2,000.
10,000. If you say one more, I'll say 20,000. Yes. 31.
One.
Great.
S.R. Sri Prasad.
Appellants. This was said to be unclear.
Huh?
Notice may be held sufficient.
Steps to be taken in respect of R1 and R2.
Have
The notice to respondent 1 and 2 returned with a postal shara unclaimed. So and so as the notice to R1 and R2 is held hold sufficient. Post this matter for admission.
next week sometime.
Yes, next week.
Great.
Post this matter for admission on 11th September.
Great.
Yes, 32.
32 Memo.
Permit me to take notice. Permit me to take notice.
In 32.
32, 33, 34.
Memo for
My lords,
32
here,
is memo for a memo is filed for withdrawal of the appeal.
my lords, here,
Government advocate.
Huh?
I am government advocate, permitted to take notice for.
let's I appear on 32 to 35. This appeal is filed on the,
Why you want to withdraw?
let's here, page number 20 of the 4757 appeal may be seen now. Apportionment has been claimed
The
before the,
undersigned concept of the appellant has filed appeal for enhanced. It has been filed before the appropriate sign. The withdrawal memo.
my
is
lords,
filed.
here, there is some contradiction with respect to withdrawal. Here pecuniary jurisdiction more than 10 lakhs, appeal lies before the High Court. The new amendment act says that it has to be gone before the district court. Now that has been stayed. So that has become a contradiction now.
What is the appeal of the, what is the valuation of this?
My lords, here, this is a common judgment.
Hmm.
Page 19 may be seen, my lords.
Anyhow, you do not want to pursue this.
My lords, maybe some statement may be recorded and then
19 is where?
second para. The petitioner has also deposited so and so amount, 3,47,000 so and so. I am claiming for compensation, enhancement of compensation on ground of parity. It is 10,83,000. So it is coming up to for 3 acres, it will be more than 10 lakhs and above.
Hmm.
So it appeal lies as per the earlier enactment, it lies before the High Court.
One thing I'm not able to understand.
Yes, ma'am.
You don't want to pursue this appeal.
My lords, here, the office registry has
No, it's not,
direct.
nothing, what it says, non-compliance of office objections.
Yes, my
What
lords.
is that?
When I went to the registry, the section officer mentioned that since this,
Let's assume that.
yes,
Now you want to withdraw it. How does it matter?
maybe it is recorded due to that we are,
Huh?
office has raised the,
The memo is filed, seeking to withdraw the appeal. The present appeal is filed for enhancement of the compensation. And the present memo is filed to withdraw the appeal. The memo is taken on record. and
my
the
lords,
appeal for
liberty may be
dismissal.
given to file it.
That's not, that is what, I think you should read the memo, what you filed.
Yes, ma'am.
You didn't ask for it.
My lords, here all.
What is the reason for that? Have you seen it? Your memo of withdrawal?
Yes, ma'am.
Read it. Where is the question of now asking for the liberty? Look at it, read it. What you have filed.
The registry has raised the objection.
Not the registry. Please give it. Give the file. The a memo of withdrawal is filed stating that the appeal is filed for enhancement of the compensation before the court. In view of the objections raised by the registry, they want to withdraw this petition and with the liberty to file a petition before the appropriate court. The memo is taken on record and the MFA is dismissed as withdrawn with the liberty to file an appropriate petition before the court having jurisdiction. Yes,
My lords, here.
the registry is directed to. LCR has already come, I don't think so. It is not called till now.
No, ma'am.
The registry shall return all the papers to the applicant. Yes, next,
Court fees, my lords.
33, huh?
Court fees.
The court fee that's paid shall be returned. Yes. 33, 34 to
35.
35.
35.
36.
Please, ma'am.
To withdraw the bill with liberty to file, my lord, before the jurisdiction district court.
This order is passed by whom?
Senior division.
The memo is filed seeking permission to withdraw the appeal and to, with the liberty to file a petition for the appropriate court. Say memo is taken on record and say like in the other case, permission is granted and the original records shall return to the appellant. Yes.
37. For the respondent caveator, my lords, no copy has been served of the appeal memo to me.
There is no note, my lords, in the registry, lords, since he has filed the caveat. But otherwise, I am lords, I am having a copy, my lords, if my lordship permits. Urgency is this, my lords, Monday, my lord, day to day, my lords, matter is keeping before the trial. Lords, I am permitted to serve, my lords.
The following office objections, translated copy of.
Translated is ready, my lords. Only English translation, they have sought, my lords, only annexure M and N. Lordship, my lordship permits, my lords, I will.
You're filing
Lords,
to be produced.
Lords, Kannada version is already there, lords. The office sought for not the English version, lord, that is ready, lords. Only, lords, to show that, lords, she was residing in that address. That is the only thing.
No. How you are serving her the papers? We'll have it on Monday.
Lords, Monday, lords, the day to day, lords, the trial court is
Monday,
keeping.
Monday, on the top of the list, print the name of, our name is there. Aishwarya. Name of Aishwarya. Papers are served on the caveator. Yes, next.
38.
Permitted to place, not of the English version.
Yes. Yes. The office objections are complied with. Yes. Pose this matter for admission. Yes.
Appellant is
38.
matter, 1 week times, 1 week time.
38 is on the maintainability of the appeal.
Also, regular counsel is out of station.
Poses matter after a week. Yes.
39.
9, Lord.
Yes.
Yeah. For the appellant, there are two objections I'm told, Lord. One is with respect to the scheduled property not matching with the schedule to the plaint. Lord, there's one small.
The first is non-filing of necessary application with respect to appellant herein, who is not a party in trial court.
That's not correct, Lord, because I'm a party in the proceedings in the trial court. There's a mistake committed to the
Since he is
registry.
deleted as per Annex D.
No, no, please see
What
the
is
order
that?
itself. The
You are read as?
I'm arrayed, my lord, as defendant number 23. What had happened, my lord, was this is an old suit of 2003. At that time, I was not arrayed as a party.
Suit of 2003 is still pending.
And in that, an injunction has been granted now for the first time in 2024. No, 2003 suit, my lord, was decreed without us.
Oh,
Then, my lord, an appeal was filed.
it was decreed on in the year.
Lord, the suit was decreed.
No, come to the cost title. I'm not able to see. It's only defendants. Where is the impugned order?
But impugned order is at page number 23.
It only says defendants.
Yes, ma'am. And lordship, see at the bottom, opponent defendant 23 is Rizwan Razak, who's the director of the
Opponent defendant number 23.
23.
Rizwan Razak.
Razak, who, my lord, is the director of Cessna Garden Developers Private Limited. So Cessna Garden is the party because that's the owner of the property today. Now, my lord, they've seen that and said, we are not a party to the proceeding.
No, because who is the appellant now?
Cessna Garden Developers. Can I request, my lord, to look at page 75, not the
No,
plain?
no, if you say.
Yes.
Rizwan Razak. He is as a.
That's how it shows. Please see page 75.
What is happening is in Karnataka,
Huh.
all this at the trial court, whenever an order is passed.
Full
they're
cost
not-
title is not there.
Should be there.
Should
That's a bare minimum. No, even sometimes, at least in this case, you find the order. Otherwise, you have to look at it. Where is the order date?
Yes.
And looking at the signature, sometimes it's visible, sometimes it's not. Which page you want me
Page
to?
75, Lord, is the plaint. Please see defend number 23 there. Messrs. Cessna Garden Developers Private Limited.
Where is this Rizwan Razak?
Rizwan Razak is the director of the company. The owner of the property is Cessna
No,
Garden
but
Developers.
ultimately he is made a party to this.
But actually Cessna is, well, that's another problem which we have nowadays here. They'll put the name of the director first. But he's actually should be at the end saying representing Cessna Garden Park.
No, that is true. But
Yes.
he should be at least either on the first or last, his name should have been there. If it is not, it should be clarified.
That's clarified, no, saying authorized signatory has signed.
Who contested before the trial?
Authorized signatory itself.
Let's see, where is that, which petition he has filed? 23 has filed his objections. Let's see who has filed.
Yes. Where's statement of objections? Page 46. Page 46 is the objections filed by pen number 23. And the signature, my lord, will come to page 53. Signed by the authorized signatory. For Cessna Garden Developers Private Limited, authorized signatory.
So then this cause title should be in the same thing. Maybe somebody is authorized to file an affidavit, but party should be the same. How he is arrayed in the trial court. Say the so-and-so company represented by the director so-and-so.
Correct.
Then whoever is authorized by the company to file or this person authorizes, he will file. But he can't be a plaintiff defendant.
Defendant is actually Cessna Garden Park Developers.
No, if you say for the trial court, you should say that array of parties is wrong. I should be the I should be representing it, but not that person. No, when an at appellate stage, no, it's not for the appellate court or the section to look at it, what is the,
I know, my lord. But anyway, that.
that has to be complied with. That office objection saying that so and so.
I can then modify the plain plot to only show his name on the top
Hmm.
and say it's represented by the authorized signatory, because that's all there is.
That should
maybe
be done. Let them do that. What is the other one?
Yes, the other one is there's a mistake in the schedule, I'm told.
With regard to non-furnishing of copy of trial court to verify schedule details stated in appeal memo.
No, there's a small mistake in the schedule that we'll correct.
That
We'll
has-
correct that
then
schedule.
Note below cost title of appeal memo with regard to respondent number 14(2). It is submitted that counsel of the appellant has filed copy of email, served copy to caveator instead of served copy of acknowledgement.
They sent it by email.
Notice to the caveator,
Caveator
respondent
notice-
number 14.
Caveator notice has been sent by email and that email was filed. But anyway, my lord, we'll serve it. The email was filed in the caveat itself, so they emailed the entire papers to him. But I think,
No, already sir, the things are becoming so complicated.
I know, my lord,
Let's
lordships
not-
may have it.
Let's not have it.
Lordship may have it next Wednesday, my lord.
Huh.
We'll comply with all
This
of these things.
matter on Wednesday, by the time the office objections shall be complied with.
40. Venkatareddy CM.
Yes.
Officers seeking petition copy.
Which
See-
petition?
See, Miss, she is seeking arrears. Main petition copy I have produced. She filed in 2 petitions for different years.
No, that is relevant.
Order sheet itself is the amount is mentioned.
No. No, it's not about whether it is mentioned or not. When you're questioning a particular order, basing on what application that order is passed, what are the objections that are filed, those 2 are the relevant documents.
Because FLW has issued and break open the that is urgency. Can I have it Tuesday?
You know that come up on Monday with the relevant petition is required. We can't dispense with the requirement.
Petition copies, I have petition copies.
File it before the trial. It will come up on Monday. File it
Monday, it may not possible to send back the file.
Tuesday.
Tuesday, can I have it?
Post this matter on Tuesday. By the time the council if the council for the petitioner complies with the office objections, post this matter for admission.
List
Done?
number 3.
Hmm.
List number 3, serial number 1. Prasad BS.
There was a connected petition arising out of the same order, my lord. We had made submission that this petition to be connected with the other petition. It is reserved for
This
judgment.
list is, this is after yesterday, after, why second list for dismissal? We have not, no, this is not non-comprehensive, that doesn't appear to be, let us take that. Yes,
Lord, there was a connected matter where we had made this appeal memo, we act along with that matter, my lord. The matter is reserved for judgment. So I could not verify the order sheet, my lord. I will make a necessary application either to withdraw the petition or to tag along with
at
it.
the request of land counsel for the appellant, pose this matter on Thursday, delete from the caption dismissal. Yes, next.
Serial number 2.
No, because don't call it all the dismissal matters, let it come up again. Because I don't know whether they are aware that it will be taken up at 2:30.
Serial number 3, madam. 6, 7, 8. Serial number 3.
You appear in?
No, I appear in serial number 24, third list.
No.
Serial number 3, madam.
No, from, no, 2, 3, 4, anybody appears? No? 2, 3, 4, let it come again tomorrow. Yeah, no, not in 4:30 list.
Serial number 3, madam. Serial number 3, madam.
No, 1 minute. 5, all these dismissal matters, let them come tomorrow. Don't 4:30, let it be at 2:30. Let's not have a 4:30 list. Because this is a practical difficulty. Then
6, 7,
10.
6. I am
6.
appearing for appeal. A week's time, my lord, I will comply the office. Yesterday it was listed, my lord. For some
Because
reason,
there was
I
no
did not appear. but
6, finally a week's time is granted for complying with the office objections, same default order. Next.
7, 8.
6, 7 and 8. Yes.
Serial number 3, madam. 1 week time. Serial number 3.
We are coming in line. Please wait. Next 10.
10.
Non-compliance objections for second time. Finally, in this also, a week's time default. 11, 12 also same. 13. Same default order. 14. Huh?
Filing LR application. please.
Uh,
I need.
Not here, file it in the section
File it in the
of.
section. I
Here
made
it doesn't show any office objections. What officer? 14 and 15, they're not showing, just like that, like non-compliance, they have 14, the
2 weeks time may be granted.
2 weeks, 14, 2 weeks time is granted, same default clause. 15, 16, 17, finally, a week's time, give one date for all these matters to come at 2:30. Next week at, on Thursday or so. Right from.
17.
Only from? Till 20.
Serial number 17.
17.
Weeks time.
17, I give weeks time. In everything, weeks time is given. Default order. What did you say? Your case?
Serial number 3, my lord.
3.
List number 3, serial number 3. 1 week time.
Oh, it's already over 3. You want weeks time? 3. 3 a week's time. Same default order. No. Huh?
19.
Weeks
time may be granted.
It's already given in all the matters weeks time.
Correct.
Yes.
20.
21. All in 21, 22, 23, the entire list, finally a week's time. And let it come up on one day, that's on Thursday, at 2:30, not.
24. 17. Sorry.
Huh?
17. Not on Thursday. Not.
Then do one thing, instead of Thursday, all these matters, only one day will give. Let it come up on, what is today?
Friday, Saturday.
Let it come up on 9th, all the matters. Now, today, whatever is adjourned with regard to office objections, that all of those matters come on that day.
May I request your lordship, serial number 24 in the third list, my lord. In this, the RFA was converted into MFA, my lord. And we have to arrange the RFA papers, the annexures in the MFA appeal papers. Office may be directed to provide me to take out the papers from RFA file and reorganize in the MFA file so that I can, the only objection of the office is index to be properly written.
It is submitted that, converted the converted the RSA.
RFA into
RFA
MFA.
into MFA. And for the office objection is with regard to the index. Land council submits that. If if they may be permitted to rearrange the RFA into a MFA.
All annexures of RFA in the MFA appeal.
All annexures of RFA into MFA, yes. Post this matter of after a week. Accordingly, the appellant is permitted to carry out the office objections post after a week. Yes.
Much
First over matter.
Number 10.
15, 1 week is.
What passover? Better unnecessarily.
I'll fight it out.
The appeal, that 2:30 matter. Dismissed as withdrawn. Signatures are there? Yes, sir. It's okay.
Madam, serial number 4. ನಿಮಿಷ ಇದೆ ಮೇಡಮ್ ಯಾರು ಇಲ್ಲ ಇಲ್ಲಿ ಆಫ್ ಮಾಡಿ.
ಅದು ಆಫ್ ಮಾಡ್ಬಿಡಿ.